All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is file case CBC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Kresnici.
Thank you, Madam Court Officer. First, on behalf of the court, I would like to apologize for this delay. Unfortunately, there has been some connectivity problems between the court and the outside world, which led to some difficulties to be able to hold this hearing. But it seems that everything has been now fixed, and I see everyone in the various screens, so we will be able to proceed. I just inform all the accused and parties attending remotely, please inform the court immediately if you have any connection problem in case we have, again, problems with the connections this afternoon. Now I would kindly ask the parties and participants to introduce themselves, starting with the SPO. Mr. Prosecutor, please.
Good afternoon, Your Honor. Appearing for the SPO this afternoon are Senior Prosecutor Alan Tiger, Head of Investigations Ward Ferdinandus, Legal and Disclosure Expert Clemence Vol-Marveli, and I am Prosecutor Matt Holling.
Thank you, Mr. Prosecutor. Now let me turn to the defense, starting with Mr. Kehoe, please.
Good afternoon, Your Honor. Gregory Kehoe, Sophie Meningon, and Bonnie Johnson on behalf of President Thaci. Good afternoon.
Good afternoon. Thank you, Mr. Kehoe. Mr. Emerson, please.
Good afternoon, Your Honour, and to those inside and outside the courtroom. My name is Ben Emerson, and I represent Kadri Veseli, together in court with my co-counsel Andrew Strong and Annie O'Reilly, with Pascal Langlais, our legal associate, with Samir Sully, our legal associate, Haradine Kuchi, a legal advisor to the team, Gabriel Cohen, an intern, and I'm joined remotely by Kwitim Kiveshi, Head of Investigations in Kosovo.
Thank you, Mr. Emerson. Now I turn to Mr. Young, please.
Good afternoon, Your Honour. David Young for Mr. Recep Selimi today. I'm assisted today by co-counsel Mr. Jeffrey Roberts, Dr. Radina Yassini, and our intern Sierra Skendo. Thank you.
Thank you, Mr. Young. Ms. Alagendra, please.
Good afternoon, Your Honor. I'm Venkateshwari Alagendra, representing Mr. Kresnici, and I'm appearing together with Aidan Ellis, co-counsel, Mr. Victor Baisu, co-counsel, and Mento Bichiri, legal associate, via video link today. Thank you.
Thank you, Ms. Alagendra. Now I turn to the counsel for victims, Mr. Laws, please.
Good afternoon, Your Honour, and to everyone. I'm Simon Laws. I'm victims' counsel in this case, appearing today with my co-counsel, Maria Radziowska.
Thank you, Mr. Laws. And finally, Mr. Nilsson for the registry, please.
Good afternoon, Your Honor. Good afternoon, colleagues. Jonas Nilsson, Judicial Services Division, representing Registry.
Thank you, Mr. Nilsson. And for the record, I note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Krasniki attend this hearing via video conference. And for the record, again, I'm Nicholas Guillou, pretrial judge for this case. On 12th of May 2022, I scheduled this 12th status conference. I asked the parties to provide written submissions if they so wished. On 18 May 2022, the SPO and the 3 defense teams submitted their written submissions. I thank the parties for their written observations. The purpose of our hearing today is, as usual, to review the status of the case and to discuss the topics in our agenda, specifically disclosure, defense investigations and next steps, and proposals for streamlining the case. I will invite the parties to present their views in a concise fashion about each item. Before we move to the first item on the agenda, as a preliminary matter, I would like to clarify the briefing schedule for any request for leave to appeal my recent decision confirming amendments to the indictment. I note that on 2nd May 2022, I ordered the Thaci defense and remaining parties to request certification to appeal the confirmation of amendments decision and to provide submissions on the admissibility of such request by Monday, 23 May 2022. I further note that on 10 May 2022, I ordered the SPO to file a response to the Vesely request for leave to appeal the confirmation of amendments decision by Monday, 23 May 2022. In light of the Thaci defense recent notification, which is F799, that it will not be filing a request for leave to appeal the confirmation of the amendments decision, I would like to hear from the remaining defense teams whether they intend to request leave to appeal and or to provide submissions on the admissibility of such requests. And I will start with the Selimi defense team, and I will start with Mr. Young, please.
Your Honour, thank you. We're not making submissions.
Thank you, Mr. Young. Ms. Alagendra, please.
We're not making submissions either, Your Honour.
Thank you, Mr. Alagendra. Mr. Kiyu, I guess you don't.
We stated our position in the filing, Your Honor.
Thank you. Mr. Emerson, would you like to mention anything?
No, I think unless Ms. O'Reilly has an issue she wants to raise.
Ms. O'Reilly?
Your Honour, as you know, we have filed our submissions, but those were filed before you issued that order. And so, as I stated in the submission, we just need clarification on the admissibility issue when you would like that addressed. Thanks.
Thank you very much. In light of the party submissions and in order to streamline the briefing schedule on this matter, I will issue my first oral order. I order the SPO to provide submissions, if it so wishes, on the admissibility of Mr. Vesely's Rule 77 request in its response due Monday, 23 May 2022. I further order the Vesely defense to file its reply to the SPO's response by Friday, 3 June 2022, and to include therein any submissions on the admissibility of its leave to appeal request. This concludes my first oral order. Let us now move to the first topic that was listed in our agenda, which is disclosure. I will give the floor to the parties on the disclosure of each category of material, as usual. So we will first start with the Rule 103 material, which is exculpatory material, as mentioned in the scaling order. Then the Rule 102.3 material, which is material relevant to the case as listed by the SPO. And finally, Rule 107 material, which is protected material for which the consent of the provider is requested. Let us start with the disclosure of exculpatory material today, given that it is the most important evidentiary material that is left to be fully disclosed to the defense. Since the last status conference, the SPO has disclosed more than 1,000 documents pursuant to Rule 103 across 14 disclosure batches, if I'm not wrong, given that the last batch has been disclosed this morning. In its written submissions, the SPO indicates that it has finalized its initial review of exculpatory evidence in its collection up to the end of January 2022. This includes the 2,500 items whose review was ordered at the last status conference. However, the SPO specifies that Rule 103 disclosures will necessarily continue as they would in all other cases of this nature, And the SPO indicates that it will conduct targeted searches throughout the proceedings to ensure that upcoming witnesses have all Rule 103 disclosures duly accounted for. The Thaci defense expresses concern that such a significant amount of exculpatory material has only been disclosed by the SPO now. It also asks the SPO to confirm whether and what amount of exculpatory material remains in its custody, control, or actual knowledge, and when disclosure of such material currently in its possession will be completed. The Vesely defense and the Krasniqi defense also request an order requiring the SPO to complete all Rule 103 disclosure by 22 June 2022. I invite the SPO to reply to the defense questions and to indicate if there is evidence at its disposal since the end of January 2022 for which review for exculpatory material has to be performed. If so, can the SPO commit to do so before the next status conference? Mr. Prosecutor, you have the floor.
Thank you, Your Honor. And yes, we'll address all of the questions that you raised just now. As accurately summarized, the SPO has completed a Rule 103 review of its collection for materials up to the end of January 2022. And to date, overall, the SPO has disclosed over 5,500 items under Rule 103 to the defense teams. We are preparing a protective measures request in respect of certain Rule 103 material, which we would file by the end of this month. As to the defense written submissions about completing Rule 103, and Your Honor mentioned the next status conference, yes, we can. We're in a situation where what's being reviewed is the more recently reviewed items. This is still going on, but this is kind of where Rule 103 is at this point. New things will come in, they'll be reviewed for exculpatory information, and this is just by rule going to continue throughout the proceedings. We're going to be able to finish reviewing the things received since January by the next status conference. We're intending to do that. So deadlines of the kind proposed in the defense written submissions are in our submission not necessary. When the SPO identifies information as falling under Rule 103, we're going to proceed to disclose it. And as we said in our written submissions, these new items are going to come in, and when they're assessed as relevant, they'll be disclosed accordingly. We just want there to be no confusion about the fact that Rule 103 disclosure packages are going to continue, and existing items can always be potentially reassessed following the initial review. The scale and development of these kinds of cases makes it important, and this reflects the best practices of the ICTY and the ICC as well, that there needs to be targeted re-reviews and searches throughout the proceedings in order to ensure that potentially exculpatory materials are fully accounted for. And we will be doing this going forward as a safeguard throughout the proceedings. But the initial review is done, and the defense has the Rule 103 information it needs to write its pretrial brief, conduct its investigations, and prepare for trial.
When you say the initial review is done, it is done for material in your possession at the date of 31st January 2022. It is not done for the material that you obtained since that date, correct?
That's correct. And so we're reviewing, as we will going forward, the new received material. Your Honor mentioned by the time of the next status conference. That's a reasonable time frame for us to do that.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, Your Honor. Thank you. One of the fundamental problems in the entire handling of this case by the SPO is their failure to do things promptly. The one thing that our clients look at, my client and the other three, is to move this case along and bring it to trial promptly. We are still, years later, awaiting 103 material, which Your Honor, on several occasions, has told the prosecutor to release immediately. Immediately, in a common parlance, Judge, I'm not trying to interpret this too broadly, means now, not somewhere down the line when the SPO decides to do it. And I bring to your attention the delay of very significant witnesses that have just been given to us within the past several days and weeks. Disclosure package 249, disclosed 18 May 2022. There's information in there going back to 5 February 2015. In disclosure package 248, disclosed the day before, 17 May 2017. There are transcripts of interviews by the SPO in December of 2019, February 2019, April 2019, and May 2019. In disclosure package 242, disclosed on 13 May 22, there are notes concerning meetings by the SPO in December 16, 2016, and January 2017. Now, that is not immediate. Now, as to any argument that this information is not extremely important to my client and the other accused, these were OSCE personnel and UNMIC personnel, key individuals on the ground at the time that we're getting 103 material, Your Honor, years after this information has been provided to the SPO. I am sure, Your Honor, based on your edict to disclose immediately, years is not what Your Honor had in mind. And what does this do? This causes immeasurably more time and effort to try to get into this exculpatory material that had been in the SPO file for years. There's simply no excuse for this, which is why we called upon an independent monitor to come in to examine this 103 material and to get it released to the defense promptly. That simply has not happened. And now we have some amorphous discussion about the potential for more 103 material after the initial set that goes from January 2022. I mean, how much is that? How much more information do we have? What is the substance of that information? All of that impacts our clients as it pertains to time, because they're the ones that are sitting in the detention unit. They're the ones that are suffering from this delay and want to bring this to trial, but we're not getting this exculpatory material. I'm sure you understand the point, Judge, the point to get this immediately, as Your Honor has articulated and ordered on numerous occasions, but frankly, Your Honor, it's just not happening. If we can address a particular 103 concern that we have, it has to do with our specific request of the SPO for evidence of contact with witnesses on their witness list with any organ of the Serbian state. That had to do, we also asked for the evidence, the provenance of any evidence which demonstrates that the source of the SPO evidence and witnesses, directly or indirectly, is the Republic of Serbia or any of its organs. Now, we got an answer back from the SPO on that score, and we had made those requests back in March. We got an answer back from the SPO on 20 April 2022. And this is what they argued. The SPO does not accept the proposition that evidence provided by the Serbian authorities or obtained with their assistance, whatever that means, automatically falls under Rule 103. The SPO is entitled to seek the cooperation of third-party states pursuant to Article 55 of the law, and such cooperation does not without more affect the credibility or reliability of the SPO's evidence. The SPO has an office in Belgrade. They don't have an office anyplace else. They are cooperating with the Serb authorities. And what do we know about how the Serb authorities have manufactured incidences in order to make our clients and the Kosovo Albanians put them in a very poor light? We talked the last time about false flag operations. My colleague, Mr. Young, will talk to you about the Panda incident. It was well reported from the latter part of '98, where the Serbs went in and murdered Serb individuals, young men and women, and blamed it on the Kosovo Albanians. And you say, rightly so, well, that was back in 1998. This is 2022. Well, the story gets better. And if we can just briefly go through where we are now in this relationship between the SPO and the Serb authorities. Keeping in mind that the foundational document for this court is the Marty report. And what had been reported both in his book and in television media in Belgrade was that the former ambassador of Serbia to Switzerland was responsible with the Serb organs to give in excess of 1,000 documents to Mr. Marty. They did that in secret back in 2009. And the ambassador, Milan Sanprotic, says that the Marty report is largely based on the 1,000 pages that Mr. Marty received from the Serbs. And he notes, and this comes from one of his interviews in one of the chat shows that was taking place in Belgrade. If it were not for the report of the Serbian war crimes prosecution, there would have been no Marty report. He talked with pride how the Marty report was replete with the information that Mr. Marty had received from Serb research organs. Fast forward, what has happened most recently? What has happened most recently is the discovery of the assassination attempt of Dick Marty. We noted for that in our submission for pretrial release. And what has happened as a result of that? Well, what happened as a result of that was that the Serb authorities put out a contract to kill Mr. Marty and to blame it on the Kosovo Albanians, accomplishing two very important things.
Mr. Kyo, we're talking about disclosure of exculpatory material. So,
and what I'm talking about, Judge, is why their position is contrary to 103 because of their relationship.
Very good.
With their relationship with the Serbs calls into question, and I've cited this many times, Judge, that it is 103 material if the information affects the credibility or reliability of the special prosecutor's evidence. So here we have a situation where the murder contract goes out on Dick Marty. Serb intelligence hires in a black ops operation a cutout to get him to kill Mr. Marty. And when did this happen? This happened almost shortly after our clients were in fact brought to The Hague in the late 2020. The contract goes out and the Swiss intelligence discover it. And Mr. Marty in his interview, and if anybody questions whether or not this is a real threat, the Swiss intelligence services have put Mr. Marty in protective custody. And it's all in his interview. The threat apparently comes from certain circles of Serb intelligence services who have asked the underworld, professional killers, to liquidate me simply to blame the Kosovos. They are part of the underworld. They are veterans who specialize in warrant killings and commission. So it doesn't take a lot of money to get them killed.
Mr. Kihu, please move to your argument regarding exculpatory material. We are talking about the schedule for the disclosure of this kind of material. The question is that you dispute the interpretation of the SPO of exculpatory material, then explain it. You don't need to get to the level of detail. We have a very busy status conference and we're already starting an hour late, so please.
And Your Honor, the bottom line is this. To take a position that the relationship of the SPO with the Serb organs on any level is the same as the relationship with anyone else is specious. We are entitled to know the provenance of any document that the SPO is advancing in this courtroom that comes from Serb intelligence or any other investigative organs. And the reason I needed to go through the Marty situation is that the threat that the threat here by the Serb intelligence services to infiltrate and obstruct justice in this case is ongoing. So consequently, clearly, any document, any information that they are getting from the Serb intelligence service or from their prosecutor's office, given this historical background, to turn this entire court upside down is 103 material, Judge. And that is the argument that we have. And the reason why I needed to go through the Marty situation is to bring to Your Honor's attention that this is a clear and present danger to this court. And the way to, just one way, other than conducting an obstruction of justice case, one way is to ensure that the prosecutor identifies every document that they got from the Serbs. Thank you.
Thank you, Mr. Q. I will give the floor to the SPO after all the defense team to respond on this argument. I think the main question here is the scope of the Rule 103 exculpatory material. Mr. Emerson, please.
Your Honor, can I deal with three issues? The first, and this is a question of clarification. It's a request for clarification. Your Honor ordered at the last status conference that the documents in the possession, or the information in the possession of the SPO up until the January cutoff line for that purpose, which was, I think, said to be about 2,500 documents, should be reviewed and disclosed as relevant. Now, we are told in what may or may not be a carefully worded written and oral submission that the review has been completed. What I would like clarification of is whether the prosecution is asserting that it has disclosed everything that it is required to disclose under Rule 103 as a result of that review of material up to that date. Because what we're told is that it's been reviewed. Certain material has been disclosed under Rule 103. What we're not told in terms yet, perhaps that will be clarified, is whether the SPO has in fact complied with your order to disclose by the 20th of May all documents that are assessed as being disclosable under Article 103, following what we are told was a comprehensive review of those documents. If what I've just said is not an accurate statement of the SPO's position, then they're invited to confirm the position and to explain why the deadline was not met, and precisely to clarify where matters stand now. Secondly, it's extremely important that the SPO is not permitted to slide into the practice of disclosing exculpatory material just before a witness is brought to court to give evidence. And I note that a new form of language has entered into the formulations put forward by the SPO. Of course, they have a continuing disclosure obligation through to the close of the evidence, and questions of relevance may change, and it's absolutely right that they should and must review what they've disclosed so far by confirming through a targeted search whether there's anything material relating to a witness they're proposing to call that has come up since the trial began. That's an obvious a corollary of the fact that disclosure of 103 material is a continuing obligation. So if that's all that the SPO is saying, then I'm sure there'd be no a difference between us. But our concern is that when we are speaking of targeted searches, the prosecution is not conducting those searches now, or has not completed those searches yet, and is in effect allowing themselves an endless discretion. So all I would like to ask is that you impose an order that if they have failed to conduct those searches by the beginning of the trial, they should not be permitted to simply allow the process to go on. In other words, those searches need to be conducted as part of the present disclosure exercise, so that insofar as the May 2022 deadline applies to material in the prosecution's possession before January, I would like to invite Your Honour to clarify whether targeted searches of all relevant witnesses have been conducted on that material before, or rather as part of the review, and have been disclosed, because the language that's been used is open to a number of interpretations. And whilst we accept that there's a continuing obligation as after the trial begins, that is not an excuse for not conducting the disclosure exercise now. And if material is disclosed at trial, which ought to have been disclosed at this stage of the proceedings under the orders that have already been made, then that is something which is likely to generate significant delay in the trial process itself. It's self-evident that if we get materials the week before, we'll need an adjournment before we can deal with the witness. And so I'm putting a marker down now that we would not expect any further material emanating from targeted searches that was other than material that had come into the possession of the prosecution prior to the 20th of May deadline, insofar as it relates to material in their possession prior to the January period. And similarly, so far as the material which the prosecution undertakes to review by the next status conference, the obligation is to review and disclose by the next status conference, not simply to review. And the review obviously includes targeted searches. The concern we have is that the language being used is wide enough to accommodate a position where the SPO still has material that it's yet to disclose. And we've heard references to redacted material, no indication yet of the volume of material which should have been disclosed by the 20th of May, with redactions being sought if necessary, and the material which is currently being withheld. And we are also concerned that the shift in language to, quotes, reflect the best practice of the ICTY and ICC prosecution officers without citation, it is in fact being put forward. I mean, why would it be necessary to raise the point, given that it's self-evident that the obligation is continuing, unless the SPO was seeking to provide themselves with a cover for not conducting that targeted search exercise at this stage, which is what in our submission is required by Your Honour's order. So that's the second point. And then the third point is simply to echo Mr. Kehoe's general submission that some of the material that has been disclosed under Rule 103 came into existence as long ago as 2015, 2017, including documents that were generated by the SPO themselves. And secondly, that we hear the difference of view between Mr. Kehoe and the SPO in relation to whether material emanating from Serbia is inherently suspect. And we would simply point out that there is very clear evidence on the record from the ICTY trials that the Serbian intelligence service deliberately set out to corrupt the evidence that was called before the court. And one witness expressly acknowledged that was the case, that he had been put up to testifying by the Serbian intelligence service and that the testimony he was giving was a lie. So we don't accept for a moment the proposition that to the extent Serbia can be shown to have its fingerprints all over the evidence on which this indictment is based, that could be anything other than the most relevant material for discrediting the prosecution case. Again, we have evidence on record in the ICTY that the RDB, the Serbian intelligence service, engaged in a whole from the senior Serbian intelligence official responsible for Kosovo, that they engaged in a wide-scale practice of blackmailing, bribing, and threatening individuals into signing documents which would provide testimony. No doubt, some of which is likely to be sought to be adduced from the bar table by the prosecution. And so the provenance, if I could put it that way, of evidence emanating from Serbian officials who are presumptively corrupt as far as these proceedings are concerned, because they are inherently partisan and have set out to drive this process. And the SPO, we suggest, has been a willing vehicle for that manipulation. And I just give you on a couple of examples without referring to specifics. Amongst the material we have received, and it goes back a period in the region of 5 years or thereabouts, is information covering the reliance by the SPO on a convicted Serbian war criminal to provide data relevant to this investigation. And in addition, as Your Honour will know from the litigation on provisional release, one of the witnesses that the prosecution continues to rely on as regards Mr. Vasili is a man called Nazim Blacha, who is dead, and in relation to whom there has been publicly available evidence since 2019 that he was a Serbian asset. In other words, he was a paid asset of the Serbian intelligence service. So leaving aside the other issues about his credibility, the notion that the SPO have failed to disclose material relevant to that through their Article 103 review of a witness whose credibility has to be very thoroughly tested because he's not here to testify in person, that material has still not yet been a part of the prosecution's 103 disclosure. So overall, we suggest that there are a number of indications here that the court is being given a very carefully worded position designed to protect from disclosure the fact that the prosecution's review of exculpatory material and its anxiousness to provide that material to the defence is compromised by a determination to put forward a case that's been essentially, or rather which includes material that is likely to have been manipulated by Serbian intelligence services, is in our submission something which Your Honour should not permit. And certainly the clarification that we saw is absolutely necessary, given that first of all, that it's not clear to us that the material sought and reviewed as relevant has in fact been disclosed, or how much of it remains to be disclosed. And it's also, it seems to us, with respect, necessary for Your Honour to give an indication that the provenance of evidence that's come from the Serbian side, which on past experience, even if it has passed through the Serbian war crimes prosecution, has resulted in the calling live of evidence which was recanted and proved to be a fabrication. So we do respectfully ask for an indication that provenance as regards Serbia is in itself an Article 103 issue for any document, witness or source that comes to the court with that handicap. And I should say that there is ample jurisprudence in the ICTY to the effect that material is relevant for the court when assessing the credibility of any witness. In other words, their association with the counter-protagonist in this case, Serbia. And as I say, rather shockingly, their SPO's collaboration with a convicted Serbian war criminal and as a reliable witness in this context, it all points to the conclusion that what has been flushed out in the correspondence between Mr. Kehoe and the SPO is a fundamental issue that needs to be resolved, and it needs to be resolved now, not at trial, because it governs the disclosure obligations, the scope of those obligations as they rest on the SPO. Those are my submissions.
Thank you, Mr. Emerson. I will ask the SPO to reply after all the defense teams.
Yes, just if it would help the further defense teams to get the clarification on Mr. Emerson's first point now, we can do that if you'd like us to. Otherwise, we'll wait.
No, I will give you the floor for all the points that have been raised by the defense team. So if you can respond to Mr. Kehoe's argument about the scope of your 103 obligation, which is also a question asked by Mr. Emerson in his third point, and then the two first points of Mr. Emerson that are the... If you have disclosed everything that you have reviewed and the scope and the timing of the targeted search, if my notes are correct. Mr. Young, you have the floor.
Your Honour, thank you very much. May I make it clear straight away that we fully support the submissions of Mr. Kehoe and Mr. Emerson. The reality is that the recent media reports over the Marty assassination plot should be of great concern to this court and with respect to yourself. Given that the individual possibly most influential in the creation of this very building is now directly accusing elements of the Serbian intelligence services of seeking to falsely blame Kosovo for his own assassination, this should be something of real import that the court concerns itself with. I say that, Your Honour, I submit that because Your Honour will know very well that the most fundamental duty of any court of law is to protect its own process from abuse or from misuse. Because, very simply, courts need to ensure the integrity of their own proceedings. And if they fail to do so, the proceedings have, with respect, no value. To put this recent Marty allegation, which frankly is explosive, into context, it's right to point out that the recent Marty allegations, as Mr. Kehoe alluded to, are not isolated, but in our respectful submission, form a part of a pattern and a much bigger picture, which involves inferential collusion between the elements of the Serbian and Russian intelligence services to falsely blame Kosovo, the KLA, and effectively the four accused. In the immediate instance, we utterly support Mr. Kehoe's submissions because it's simply impermissible not to suggest that this sort of evidence, with this provenance, may not affect the credibility or the reliability of the evidence. The provenance is critical, and prima facie, it falls into category 103. Three short points in relation to the bigger picture of the false narrative. Firstly, Your Honour, as far back as December 1998, according to the President of Serbia, who belatedly officially acknowledged this on behalf of the Serbian government, agents of the Serbian Secret Service in Kosovo's Peja, in what's called the Panda Cafe massacre, murdered a group of 6 young Kosovo Serbs, and the blame then being attributed falsely to the KLA. The net result of that was that some days later, after this shocking incident of death, murder, and severe injuries, a number of young, innocent ethnic Albanians were arrested, taken into custody for almost a year before being released, although the president, many, many years later, acknowledged it was his own agents of his own secret service that were responsible. The second part of the bigger picture, which Your Honour really should take into account, is the history of Serbian and Russian false claims of organ trafficking, because any cursory analysis of the Russian and Serbian claims of organ trafficking belie clear parallels in the Marty's report. The Russian claims in relation to Ukraine make it very clear that they mirror very similar sort of claims by the Russian state. And the Russian reports in the media of false claims and disinformation in relation to alleged Ukraine trafficking in human organs aren't simply isolated reports. Your Honour may have noticed that, in fact, the media reports in relation to Russian disinformation, which mirrors the false claims in the Marty report, are dated in 2014, 2017, 2019, and even in March this year. So finally, third point, when Your Honour is considering the Thaci and our defence submissions in relation to 103, and indeed, of course, Your Honour has before you, I don't believe a decision has been given as yet on the Thaci written filing in relation to an independent and impartial review over exculpatory materials, we do respectfully submit to you, you might want to carefully consider the fact that the reason we're all here today in this court, in these proceedings, goes back to a motion for a resolution which was tabled by Mr. Konstantin Kosachev in the Council of Europe in April 2008. It was a resolution entitled Inhumane Treatment of People and Illicit Trafficking in Human Organs in Kosovo. You may recall that Mr. Kosachev was one of the two Russian members of the signatories to the motion which he tabled. And indeed, that motion led to the Dick Marty investigation, it led to the Dick Marty report, and it led to this court. A report based on a false narrative. And the ultimate question, when you're considering these issues, is to perhaps this is one more for the historians than the lawyers or the judges, is to look at the source of the original false allegations provided to Mr. Barty, who was provided information from Carlo De Ponte's prosecutor's office in 1998. These are questions, and it's a bigger picture that demands some answers. Thank you.
Thank you, Mr. Young. Ms. Alexandra, please, or Mr. Ellis.
Your Honour, it will be me on the disclosure issues today. Very briefly, Your Honour, on this first point, the evidence from Serbia point, we strongly support the submissions that have been made by all defence teams today. The issue on 103, Your Honour, of course, is simply whether this is information which affects the credibility or reliability of the specialist prosecutor's evidence. And in our submission, the points made today about a continuum of Serbian interference in evidence between the Panda Cafe incident in '98, running right through to Dick Marty very recently, strongly supports in our submission the position taken by Mr. Kehoe on behalf of President Thaci that this material ought to be disclosed. And once it's disclosed, of course, further steps can be taken thereafter to investigate it. The second point I wanted to make, Your Honour, is very much related to the targeted searches issue that Mr. Emerson raised. The position at the last status conference was that the prosecution explained that they were doing two things. They were doing an initial review of the evidence, and they were doing targeted searches. And what they said to the court was that they were simultaneously proceeding with targeted searches related, for example, to the witness list, as a means of ensuring that all potentially exculpatory items are identified and disclosed. They carried on that the targeted searches were an additional measure to ensure that material is identified and is disclosed, and anticipated that further disclosures will be generated from those searches. They were not in a position, as at the last hearing, to give Your Honour an estimate of the time to be taken in that aspect of their review, noting that they received potentially thousands of hits from a single name, and each of them would need to be looked at. Now, that's why it's a concern to the defence when we get to this status conference and the prosecution's written submissions for this status conference, which say that there are targeted searches, but if I can just find them, but that the SPO, reflecting the best practices of the ICTY and ICC prosecution offices, as Mr. Emerson noted without citation, will conduct targeted searches throughout the proceedings to ensure that upcoming witnesses have all Rule 103 disclosures duly accounted for. So we've moved from this being something the prosecution was doing simultaneously with their review to something that they're proposing to carry out for upcoming witnesses. In our submission, that's not acceptable. In our submission, the targeted searches, we were told last time they were being conducted at the same time as the initial review. Plainly, they should be, because what the targeted searches are going to identify are things that are in the prosecution's possession now. They don't need to be disclosed in months' time when witnesses come to testify. They're in the prosecution's possession now. And at the last status conference, the prosecution was saying that they expected those searches to generate additional documents. And that's why, respectfully, Your Honour, we seek a deadline. We invite Your Honour to set a deadline today for the prosecution to complete targeted searches, including the ones mentioned at the last status conference, based on the prosecution's list of witnesses.
Thank you, Mr. Ellis. Mr. Prosecutor, so on all the questions, I have at least 1, 2, 3, 4, 5, 6. The question of the scope of your 103 obligation that has been raised by, I think, all defense teams. Then the specific question of Mr. Emerson that I recalled a little earlier. And then the issue of the targeted searches simultaneously to your initial review or later, and the question or the proposal of Mr. Ellis to impose a deadline for the targeted searches. You have the floor.
Thank you, Your Honor. We'll start with Mr. Emerson's clarifications. Just to be clear, there's no careful language here. When we said we finished the initial review, everything we've identified falling under Rule 103 either has been or will be disclosed by the end of today. The only exceptions are things that are going into the protective measures motion that we said we would file at the end of the month. So the review and the disclosure are going hand in hand. On the targeted searches, there is not an initial review phase and a targeted search phase of what we are doing. The targeted searches, they're going on now, they will continue into the future, they're not just limited to witnesses. This is about vigilance. This is about us making sure that at all times we can give as full account of Rule 103 as possible. So it's something that we think it's a best practice as an office to be doing throughout as a safeguard throughout the proceedings. But it's a safeguard of already reviewed material. The only things that have not been reviewed yet are the things I mentioned to Your Honor earlier about the items since 31 January. And as I said, we are doing this review. It will be finished next month, and we'll keep doing it as new material comes in. As to the scope of the Rule 103 obligations, Mr. Keogh read out our position in court. That's our position. We consider these requests in relation to everything that has had any involvement of the Serbian authorities falling under Rule 103 to be an overbroad and unjustified request. And the defense teams keep making this request in different contexts, and the latest version is now this information about Mr. Marty and this Serbian assassination plot in the media. As Your Honor may be aware, this is not the first KSC panel that has had to be confronted with this issue. In the Gutsadi Haradnai case, trial panel 2 was seized of a motion in the last 2 weeks about this very thing and wanting to reopen the evidence proceedings. And at paragraph 16 of decision KSC BC 2020-07 F00610, this is what the trial panel said. The reported matters entail unverified allegations of impropriety on the part of Serbian authorities, which appear unrelated to the SPO's cooperation with such authorities. Maybe there is more that the defense teams have, but rather than sending us emails on this topic or raising it off agenda items in a status conference where they don't really belong, what we would ask is that the defense teams file a formal written request asking for disclosure of this information, presenting their full legal and factual basis, and we'll respond to that accordingly. But in our view, this is not a failure in our appreciation of the scope of our Rule 103 obligations. This is an overbroad understanding of the defense on same.
Thank you, Mr. Prosecutor. Mr. Keogh, please.
Your Honor, It's very unfortunate that this position has been taken by the SPO. They are in lockstep with Serb entities as part of investigating these cases. They have a job application for people to get a job in Belgrade at their office. Do they have an office anywhere else? I submit to you, I don't think they have an office in Pristina, but they have an office in Belgrade. They have approximately 5 witnesses from Serb organs that they intend to put on in the witness box. We have a litany of documents that undoubtedly come from the foundational report for this court, i.e. the Marty report, that then went to the Special Investigative Task Force and then that came here. Counsel misunderstands the rule. If in fact evidence and information comes from an unreliable source, question, looking at Rule 103, may that reasonably suggest or affect the credibility or reliability of the specialist prosecutor's evidence? May it affect? Clearly it does. We have a source of documents coming to the SPO that the SPO is using routinely that are coming from a source that is manufacturing evidence, that is making up stories, that is putting forth a litany of allegations, not the least of which is the organ trafficking allegation that, of course, didn't make it to any indictment, that are central to this case. Now, the big difference between this case and the Haradnaj case that was just finished was that's clearly an obstruction case involving much different issues. These issues in this case go back to at least 1997 and before. During the entire time when the Serbs were involved, where they were gathering evidence, when they were putting all of this facetious, all of this false testimony out there, these false documents out there, these false flag operations, until one might think that with the court established that all of this would stop, and lo and behold, it does not. What happens is we still have yet more dirty laundry out there where they're attempting to assassinate the person who was responsible for this court, blame it on the Kosovo Albanians. That's what the Swiss intelligence services reported. Blame it on the Kosovo Albanians, and of course, to eliminate the one witness, Dick Marty, that could clarify all of this. A fundamental act of obstruction for this court. It is inconceivable that documents that are coming from the Serbs, given the litany of falsity and improper conduct coming from the Serb governmental organs, that the provenance of those documents would not affect the credibility of the SPO's case. To turn it another way, given everything we know about what the Serb authorities were doing, how could the documents that the SPO has received and is using not affect the credibility of the SPO's case if those documents came from Serb governmental authorities? I hate to repeat myself, Judge, so I will sit down. You understand that I'm clearly just attempting to go back and get compliance by the SPO, despite their resistance, to the rule. Thank you.
Thank you, Mr. Kehoe.
Your Honor, apologies. Before Mr. Kehoe, just in case he wants to take the floor again, to correct the record, the SPO does not have an office in Belgrade. We just wanted to make that clear.
Thank you, Mr. Prosecutor. Mr. Emerson, please.
Yeah, and I'll be brief if I may. What I want to address is the mode for resolving this very clearly defined dispute between the defense and the prosecution. Clearly, and it's rather, if I may say so, a weak argument, the issues facing the Gucciati trial chamber when asked to reopen the evidence by reference to the false flag attack on Dick Marty are very, very different from the issues facing the prosecution and its disclosure obligations in this case, not just because the case is fundamentally different, but because the reason that the trial chamber gave was that the allegation was unrelated to the SPO's cooperation with the Serbian intelligence and other sources. The issue that we are pressing is that everything relating to that cooperation should be disclosed. In other words, at the very least, whether there was such cooperation, and if so, whether or not what the details of it were. May I put it this way? It is self-evident and fully established by the ICTY that if a witness comes to give evidence about issues concerning this conflict, then the fact that they were at the time, whether officially or unofficially, affiliated with the Serbian state or its entities on the ground, was plainly a relevant issue, not just for disclosure, because the prosecution in the ICTY took it as routine that information would be disclosed. But when the court comes to consider what weight is to be attached to such a source, it is plainly and self-evidently material. That doesn't necessarily involve, despite the fact that there is a huge amount of evidence of it, both in the past and in some of the material in this case, of manipulation and corruption on the part of certain elements of the Serbian apparatus, including the prosecutor's office as regards the War Crimes Prosecution's Office, through which this material is then handed on to the prosecution. But you don't even need to go that far. It's self-evident that anything emanating from Serbia in the context of a conflict between Serbia and Kosovo, or between the KLA and the Serbian forces, emanates from a partisan source. It's obviously a partisan source by definition, and therefore the provenance is disclosable. And if the prosecution hasn't got that by now and hasn't been operating its disclosure obligations on that basis by now, then there's an urgent and very serious problem, because since they're plainly wrong in the interpretation that they're applying, there's no way that a trial chamber would allow a prosecution like this to go off all the way through to the end, based on witnesses who've been set up to give a testimony by the Serbian, let's say, intelligence service, without that being disclosed. So sooner or later, it's obviously going to become disclosable. But by then, the prosecution will have conducted its disclosure exercise as it currently is, without reference to that obligation. Why they would take such an obtuse stance is difficult for us to understand. Plainly, it will reveal the scope, that is clear, of the reliance by the SPO on tainted sources emanating from Serbia. It will provide that basis for analysis. One has to ask the question, why is the prosecution trying to hide, in an obtuse interpretation of its obligations, the extent to which it is dependent on corrupt sources inside Serbia? That is not the conduct of a responsible prosecutor. If the point was even arguable the other way, that was not a relevant consideration, then the situation might be different. But why, one has to ask, is the prosecution adopting an obtuse and an unarguable position in order to conceal from the court and the public the extent to which its case is based on a partisan source which has descended into very grave corruption, not just through the false flag operations which characterized their conduct of the conflict, but even, the organ trafficking allegation itself. Now, obviously, I'm not going to repeat what's been said about that, but the only witness ever to have testified about the alleged removal of organs in this context is the witness I was referring to earlier on, who subsequently admitted that it was an entire lie and that he'd been put up to saying it by the intelligence services of Serbia, and that he would now be dead if that once they'd found out about it. So on any view, the extent of the manipulation by Serbian sources of judicial processes concerned with this conflict has been huge. And the notion that the prosecution are now trying to keep that from the court, the parties, the accused, and those who follow these proceedings in Kosovo, and indeed in Serbia, is, in our submission, shocking. and it should be dealt with summarily. In other words, we invite Your Honour to give an indication that the provenance of material that has been provided to the SPO by a Serbian source, the fact of Serbian governmental source, that fact alone goes to its reliability because it is a partisan source. You don't need to make any findings about corruption or about the propensity for corruption, but the fact that it emanates from a partisan source to the conflict is in itself sufficient to establish that the provenance is disclosable. Serbia is continuing to mount a political campaign across the board aimed at defeating Kosovo's independent status. And the extent and manner in which they cooperate with the SPO in these proceedings is undoubtedly going to be infected by the political stances that Serbia has taken. So given that they're clearly not above manipulating judicial processes, because they've done it many times before, this is not about the a plan to assassinate Dick Marty. That's just a particularly grave example of Serbian false flag operations, all of which, in our submission, go to the fundamentals of this tribunal, because the whole tribunal was set up on the basis that it was to try Dick Marty's allegations. We now know those allegations emanated from Serbia and that they were fabricated. There isn't a single, as Mr. Kehoe said, maintained allegation by the SPO that has organ trafficking at its heart. This whole thing was, from the beginning, an attempt by the Serbian sources, and we can clearly see the intelligence sources because we know that from the evidence that's been given, to put up an entirely false case to justify this tribunal. And if that isn't a reason for saying that the provenance of evidence that emanates from the Serbian side is disclosable, it's difficult to see what would be. So in our submission, this is something that you can rule on today on the basis of partisanship alone, and on the basis that is the approach that all of the other tribunal constitutions have agreed with. If that is not the appropriate course, or you don't think it is an appropriate course, there's no point in any further discussion between the parties, because the prosecution is conducting its exercise on an entirely false basis. And it's going to take a very great deal of time for them to go back and do it all again with correct guidance. So we would suggest, if you don't feel able to give the indication clearly today so that we can get on with the disclosure exercise in a timely manner, then you should direct a very short timetable for the exchange of written submissions and rule on it that way.
Thank you, Mr. Emerson. Mr. Young, do you want
Nothing to add.
Thank you, Mr. Young. Mr. Ellis, please.
Nothing to add either, Your Honour.
Thank you, Mr. Ellis. Mr. Prosecutor, do you want to add anything? Thank you very much. On this topic, I invite the parties to file written submissions. I invite the defense to file submissions on this topic, bearing in mind that I will prioritize this question, and I invite the defense to substantiate their request, and the SPO to develop their arguments. I also invite the parties to have in mind the existing jurisprudence of the International Tribunal, and maybe also to have in mind the issues of having joint investigative teams with various countries, because this also would resonate in more recent investigations, probably. Let me now move to the Rule 102.3 material. I remind the parties that at the status conference held on 29 October 2021, I suspended the remaining defense deadline for Rule 102.3 material. Since the last status conference, the SPO indicated that it has disclosed more than 14,000 items and that further packages are being prepared. It also foreshadows that materiality challenges and requests for reductions will be necessary in respect of certain Rule 102.3 requests in the near future. I invite the SPO to indicate when it plans to make such filings. The SPO estimates that it will be in a position to address 40,000 further requests between now and 22 July 2022. However, the SPO does not consider that Rule 1023 is an area of the pretrial disclosure process for which an ultimate deadline can be fixed, and therefore opposes the proposal to set to 22 July 2022 for the SPO's review of this category of evidentiary material. The SPO explains that at least one defense team has now requested 97% of the items on the original Rule 1023 notice, creating very demanding disclosure obligations. According to the SPO, full completion of their disclosure should not serve to act as a procedural bar to transfer the case to the trial panel. And the disclosure process will continue into the trial phase. Let me be clear. I remind the SPO that I previously ordered a procedural calendar according to which all Rule 1023 disclosure was to be finalized before it files its pretrial brief. The SPO did not raise any objections at the time. I also remind the SPO that in all the other cases before the KSC, I systematically ordered the disclosure of Rule 1023 material to be finalized during the pretrial phase in order, first, to allow the defense to prepare its case before the trial starts, and second, to prevent the trial panel to be obliged to stay proceedings to allow the defense to perform specific investigations linked with the late disclosure of evidentiary material, which would, of course, delay the proceedings before any trial panel. Accordingly, I invite the SPO to indicate why it now considers that disclosure should continue through the trial phase and why it is not in a position to fulfill its disclosure obligations by 22 July 2022 as proposed in the scheduling order. The defense, in its submissions, remained concerned about the time taken by the SPO to meet its Rule 1023 obligations and the backlog of Rule 1023 disclosure yet to be completed. The defense, therefore, supports the imposition of an ultimate deadline of 22 July 2022 for the SPO's review of currently pending defense requests, notably because the Rule 1023 notice was submitted nearly 10 months ago. Without a firm deadline in place, a Rule 1023 disclosure is likely to drag on indefinitely, and delays in disclosure of Rule 1023 material directly impede the defense preparation of its case and, more generally, the case progression towards trial. The defense also indicates that it intends to make further targeted requests in the future. Therefore, while the Vesely defense is willing to commit to a deadline of 22 June 2022 to submit further bulk requests, the Thaci and the Krasniki defense do not support the reinstatement of deadlines for their own Rule 1023 requests. I inform the parties that I intend to set a deadline for the disclosure of the Rule 1023 material already requested by the defense according to Rule 95(2). I invite the SPO to provide detailed submissions on the time it needs to review and disclose the documents already requested by the defense. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. As regards the initial question that Your Honor raised about when we would be making filings for Rule 1023 material that requires protective measures, we don't have any specific date in mind. We were intending to file a motion to that effect in the near future after the Rule 103 motion, which we understood to be the more urgent one that Your Honor requires. As regards the calendar and also the practice of other cases that Your Honor has sat on and the time of our obligations, some explanation is in order. Our written submissions have set out an aggressive, but we think feasible estimate for what we think a Rule 102.3 disclosure push would look like. In the interval from the 10th to the 11th status conference, we disclosed something in the range of 8,000 items, 8,000 disclosures. In the interval to this status conference, it was 14,000 disclosures. And now we're proposing to do 40,000 disclosures. We are taking this obligation seriously. There is a human limit and a resource limit on what we're able to do, and we wanted to stress two further points in this regard. First, as to why this takes as long as it does. And it relates to the defense's written submissions as well, because the defense links the length of the pretrial disclosure process with the length of the accused detention. And they also argue that disclosure is inadequate because of the heavy number of redactions that are applied. All of these considerations are connected. We could disclose the entire contents of the Rule 102.3 notice today with a push of a button if full disclosure was the only consideration. The disclosure reviews, the checks, the redactions, the processing, they are put in place primarily to ensure that people are protected. And the necessity of protective measures have been found time and time again in this case, borne in large part by the climate of witness intimidation in Kosovo, which informs the context of the obstruction risks found in the detention context. And this climate persists into modern times, as manifestly demonstrated by the findings in this Wednesday's Kutsari and Haradnai trial judgment. What the defense are seeking in their submissions, and we appreciate that Your Honor has made these kinds of orders before, but in this particular case, it's disclosure in an unreasonable time frame given the scale of the case. And they're doing this because they are ignoring or rejecting the necessity of the protective measures which have been ordered. Incidentally, and this relates to a submission of the Vesely defense, our letter to the defense teams did not say we are agreeable to a variation of protective measures so that counsel could look at the material without redactions. We said they were trying to reconsider necessary protective measures, and the court can see the exact wording of our response in Annex 2 of the Vesely written submissions.
Would the counsel be asked to slow down, please?
The second point we wanted to stress in this regard is we're not saying that Rule 102.3 is not important, but we're saying that the defense teams are misrepresenting the importance of this particular notice in their preparations. The Krasniqi defense does this most clearly in their submissions. At paragraph 7a of F00807, they say this: plainly, the defense needs to be afforded a fair opportunity to review the disclosure of Rule 102.3 items which are, by definition, material to the preparation of the defense and defense investigations before drafting the pretrial brief. That's not true. Rule 102.3 items are not material to the preparation of the defense by definition. They are relevant to the case by definition. That is a lower standard, and it's an extremely broad standard, following the directions Your Honor has set in this and other cases in which the appeals panel has endorsed. And this means that the defense teams are routinely selecting items that are highly unlikely to be material to their preparation. And they're disclosed nevertheless, because it is generally more expedient to do that than to challenge them. But any sort of expectation that the Rule 102.3 notice selections would actually be selective, which was something that may have been contemplated earlier in the pretrial phase, has just not been borne out in practice. You can see this in some examples. SITF 00441896 is one of a series of 15 selected K4 reports whose description makes clear that they're about clearing asbestos from the K4 barracks. 060207 TRET is an interview of witness W04371 selected by 3 defense teams after the amended Rule 1023 notice made clear that it had already been disclosed under Rule 102(1)(b). SPO E00107-708 is a disclosed photo of a salamander in a dugout hole forming part of a collection of exhibits associated with a witness contact. Selected, despite the description clearly saying it's a photo of a salamander in a dugout hole. The defense is, of course, entitled to select whatever items it wishes from the Rule 1023 notice. We will disclose them as quickly as we can, and as noted in our written submissions, we're aiming to accelerate this process. Your Honor asked, when can the items already selected be finalized? We aren't able to give a reliable estimate because of all the moving parts. Our capacity is about to increase substantially with the Rule 103 review finished, and we have promised an aggressive estimate of what we can do by the 22 July date indicated by Your Honor. The point we wanted to stress is that what the defense puts forward as conditions to writing a pretrial brief are not real conditions. They're a wish list untethered to the statutory scheme. And you can actually see this most clearly in the Viselli defense's written submission, where they need to know the first 6 months of the SPO's witness order before they can write a pretrial brief about the entire case. These are not logically connected things. The full Rule 1023 condition is also something that they want, and it's rather than something that they need to write their pretrial brief, or, at least statutorily speaking, mindful of Rule 102(4), to even have this case transferred to the trial panel. What the defense need the most, they have, and the rest will come on as accelerated a pace as we can sustain.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Your Honor, when the prosecutor stands up and makes an argument like that, it can only be termed to be alarming, because virtually none of it is true. The rule requires the disclosure of items which are deemed by the defense to be material to its preparation. Prosecutor stands before Your Honor as if they have been meeting all their deadlines, that they have been complying with all of your orders, that they have been operating in a timely manner. You laugh, Judge, because it's ridiculous. It's ridiculous that counsel can stand before you and say, yes, we have been studiously complying with all of our discovery obligations. And he points to the fact, and I wrote this down, that disclosure is keyed to detention. Well, that's a fact. My client and the other 3 gentlemen have been sitting in here since November 2020 and want to move this case along to trial. But one little fact that counsel left out was when this case first came before Your Honor in the fall of 2020, that the SPO told Your Honor with a straight face that this case would be ready to go to trial in the spring of 2021, a year ago. 1 year that they said they were going to be ready to go to trial, and they have still not complied with their discovery obligations, the disclosure obligations. They still have not completed the 103 disclosures. They certainly are nowhere near meeting their 1023 obligations. And the comment of counsel that say that this has nothing to do with the pretrial brief, I am very happy. Counsel can get inside the head of the defense and make that decision for us. But Your Honor said very clearly in the last proceeding that we had before you, when the defense hasn't received all of disclosure, it's also difficult for the defense to agree on facts. We haven't received much of the disclosure. So all of this is tied together. The disclosure, what we can agree with in facts, disclosure concerning matters that have been redacted. It's all connected together. But for counsel to appear before Your Honor this far down the line, over 2 years after, almost 2 years since the day these gentlemen were put in incarceration, that they have been complying with their discovery and disclosure obligations is nothing short of specious. We need these documents. We have made requests that we haven't received. We did not willy-nilly or just on a spur of the moment ask for documents under 1023, Judge. My team doesn't have the time to read that, nor are we inclined to do that. So counsel needs to be ordered to get this done so this case can move along and go to trial. And stop with this nonsense that he puts before the court that he somehow complied with all of Your Honor's edicts as we moved along the way. It's the entire year-plus spectrum that we've been here. It's nonsense. And we look to Your Honor for some help and some guidance to get this done so we can move this matter to trial.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honor, I'll deal with the question of the order of witnesses to be called in the first 6 months of the trial when we get to the point in the agenda that concerns the date for the pre-trial briefs for the defence and the question of streamlining. Other than that, I'm going to hand over, if I may, to Ms. O'Reilly to deal with all remaining issues of disclosure.
Thank you, Mr. Emerson. Ms. O'Reilly, please.
Thank you, Your Honour. I just have a few points in response to Mr. Halling. First of all, he mentioned that we had been requesting documents already disclosed and, you know, how audacious that is. But this is exactly why I've repeatedly asked to get item numbers and to have cross-referencing so that we know that those documents are already in our possession and we can strike them off the list. So yes, indeed, that is why that has happened. As to the salamander, we didn't put the salamander on the list. The SBO did that. And it is the manner in which they approach this exercise that has caused us to do bulk requests in which the odd salamander gets into the mix. If they want to challenge the materiality of that, they can do that and we will respond. But that is a problem created by the SBO, not by us. And lastly, I would just point out that they still haven't said when they will be in a position to comply with the disclosure of the items already requested. So I wonder if we might have a more specific answer on that in the next round of submissions. That's about all I have to say for now, Your Honour. Thank you.
Thank you, Mr. O'Reilly. I haven't forgotten either. Mr. Young.
Thank you, Your Honour. Just two very short points. Firstly, in relation to when the SPO should disclose this 1023 material, I would simply welcome what Your Honour said, that, as I understand, Your Honour made it clear that in your approach in other cases has been to ensure that the 1023 material is dealt with pre-trial so the defence can prepare, which frankly is obviously logical and sensible approach. It's of no use to the defence to have it during or after a trial. It's clearly something we should have pre-trial. So the prosecution's approach in this is utterly specious. Second point, in relation to materiality, Your Honour may have noticed in their written filings recently, the prosecution are now suggesting that they may in the near future outline some materiality challenges. Why now? Your Honour knows very well that over the last few status conferences, one thing I've been routinely and consistently doing is to make it clear that there hasn't been a hint that there was ever going to be a materiality challenge. Now, I'm still short of over 42,000 documents, and now they say we're going to have a materiality challenge. Why was the court not put on notice to potential materiality challenges? That could have been dealt with a long time ago, And yes, again, they're wasting all our time.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, I'll try to be brief with the points in view of the time, but the first thing I do want to say is I don't accept for a moment that the submissions that we made were untrue, to Your Honour. If issue is being taken with us saying that 1023 items are by definition material to the preparation of the defence, we took those wording, of course, from the text of 1023 themselves. So I don't accept for a moment that our filing was untrue. Your Honour, the second point is simply the point made by Miss O'Reilly, that it was, at the end of the day, the prosecution that put these items on the list, conducting an initial review that these items were relevant. And we had submissions several status conferences ago where I think an email was sent by, if memory serves, the Salimi defence to clarify what test of relevance was applied. But in my submission, it is the prosecution that composed this list and put forwards that these documents met an initial test of relevance. But what's more important than that, Your Honour, is that what we keep finding is that items that were previously put on the 1023 list suddenly pop up in the exculpatory 103 disclosure. So what's happened is once somebody's requested them from the 1023 list, the prosecution actually looks at them and it turns out they were exculpatory all along. 12 documents in disclosure batch 249, were, an exculpatory batch, were previously on Rule 1023 notice. Documents also appearing in exculpatory batches 234, 242, 243, 247, 248, 252, even today, I think. Now, when the prosecution stands up and says what's being asked for is not material, actually, each of these disclosure batches have contained things that were not just material to the preparation of the defence, but actually exculpatory. Your Honour, the final thing, I just want to clarify the Krasniqi defence position. I stood up at the last status conference and forecast that we would make 2 further Rule 1023 requests. That we have done, as we promised to do. We are, as things stand, finished. We don't propose to make any further Rule 1023 requests, unless, of course, something crops up unexpected, something once identities are revealed as the case progresses. So we would entirely support the Vesely defence proposal for a deadline to be imposed for defence requests, subject, of course, to a showing of good reason later in the day.
Thank you, Mr. Ellis. Mr. Prosecutor, let me first acknowledge the fact that you have a lot of documents to disclose. It is true that the defense has requested a lot of documents, and I fully understand that it takes time to process a disclosure because you want to make sure that protection of witnesses and victim is ensured, and you need to spend time on each document. So I fully understand that. That said, the defense is not responsible for the scope of the case. The scope of the case has been determined by the SPO. The SPO framed the case in such a way that you had to list a lot of material in the 1023 list, but the defense is not responsible for that. Second thing, as I said in my introductory remarks on this category of material, I intend to send a clean case file to the trial panel. I do not want to send this case to a trial panel that would be consistently obliged to stay proceedings because the defense would be disclosed specific information that would lead to new investigations. That would not be a good practice, and that would slow down the proceedings at a later stage. So I intend to transmit a case file in which the defense has had access to all the evidence it is entitled to get. And that include Rule 1023 evidence, at least the bulk of the general requests that they have made. As Mr. Ellis said, there could always be specific targeted requests based on the evolution of the case, but at least the bulk of the 1023 has to be disclosed. So I will again formulate the question that I had. When do you estimate that you can finalize the Rule 1023 disclosures of the requests that have already been made by the defense? If it is later than 22 July, you can give me a tentative date. This can actually be a tentative date that could be moved if you realize that you need 1, 2, 3, 4 more weeks. I perfectly understand that. I perfectly understand that it's a lot of work and that it's time consuming. But what the SPO need to have in mind is that from the disclosure of the material depends the remainder of the pretrial phase. Whether you like it or not, it has links with the defense pretrial brief, and then with the time I'm able to transmit the case to trial, and then when the trial can start. To say it more clearly or more bluntly, the timeline of this case is in your hand, and it depends on the disclosure of the remaining categories of material. So if you want to reply to me after the break because you want to consult internally, I perfectly understand that. But I said that I wanted to issue a target date for this procedural milestone, and I stick by what I said. Mr. Prosecutor.
Thank you, Your Honor. We would like to consult after the break to give you a better indication of what Your Honor indicated. What Your Honor just said is helpful to us because it's talking about the bulk of the materials being disclosed, which is something that is going to be more feasible than getting every single item off the Rule 1023 notice processed before the case is transferred to the trial panel. So I just wanted to confirm that we'll review a proposal and see what we can give as a deadline, bearing that in mind.
To be clear, when I said the bulk, I mean what has been requested by the defense, not what they will request in the future. So I did not want to make a selection in what the defense was proposing. So again, my question is, when are you in a position to disclose and or file any request for protective measures for the material for which you think it is necessary? And I want a date for this for the material that have been already requested by the defense. That is my question, because this will be key for me to determine a timeline for this, and that will have an impact on the timeline of the defense pretrial brief, then the timeline of the transmission of the case, and then the start of the trial.
Understood, Your Honor. We'll get back after the break.
It is 5:07. If the interpreters allow me, I know you must be very tired, but we have a very, very small section on Rule 107 material that shouldn't last more than a couple of minutes. If you prefer to have a break now, we can have a break. If not, we could continue with this. Okay.
Yes, Your Honor, we can continue. Thank you.
And I know you must be tired, but thank you very much for this, because like with that we can, apart from the last point, we can continue with the disclosure. Let us now move to Rule 107 material. I note the SPO submissions that it is continuing to actively work to complete discussions with Rule 107 providers. The SPO indicated that it's preparing 2 further Rule 107-2 applications, including conclusion of counterbalancing discussions as relevant. So I invite the SPO to make submissions on this topic, notably on the timeline for the upcoming 2 Rule 107-2 applications. Mr. Prosecutor.
Your Honor, we don't have a specific date by which we're going to file those Rule 107 requests at the moment. As Your Honor can appreciate, the more clearances that we get, those applications sort of evolve depending on when they're filed. And so ideally, we'll be able to file them at a point where it's the smallest scope of issues for Your Honor to decide. Beyond that, we're just continuing to try and resolve this matter.
Thank you, Mr. Prosecutor. Any defense team want the floor on this? Mr. Kihu.
Well, generally, Your Honor, I don't say much about Rule 107 issues because I really don't know what we're talking about, but it seems like we're, again, expanding timeframes without counsel giving Your Honor some parameters as to when he's going to get these clearances. That's the problem, right? Because that is the thread that runs through everything that we've been talking about today.
It is true, but what the prosecutor just mentioned is also true, is that the more they get clearances, the less material they present in their request, and the more is disclosed to the defense. So, Mr. Emerson or Ms. O'Reilly? Do you want to, Ms. O'Reilly?
Yes, Your Honour, that will be me. I just wanted some clarification. So we're talking about two further Rule 107 applications being in progress, but there was a longer list of 107 applications that they had in a recent filing. And it's really just not clear to me right now what volume of material we're talking about, set aside the issue of timing of this disclosure. And I wonder if we could not even just get a rough estimate in terms of hundreds or thousands of pages from the SPO. And that's really about it. It's just about trying to complete this disclosure exercise so we can actually move forward to the trial panel at some point. Thank you, Your Honour.
Thank you, Mr. O'Reilly. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Nothing, thank you, Your Honor.
Thank you, Mr. Ellis. Mr. Prosecutor, do you want to reply to the question of the defense?
Yes, briefly, Your Honor. The issue with Rule 107 is not the pages, it's with the documents. So one clearance might clear a 10,000-page document. So it's not a good metric of the progress we make. The progress we make is with the providers, which for obvious reasons we can't talk about in open session.
Thank you, Mr. Prosecutor. Mr. O'Reilly?
Just very quickly, Your Honour, the volume of pages is an issue for us because we're the ones who have to read it. So I appreciate what you're saying, but we would still need that in order to prepare ourselves for trial. Thank you, Your Honour.
Thank you, Mr. O'Reilly. I invite the parties to continue these exchanges inter partes, because I think this indeed has an impact on the organization of the defense, and especially the time that it needs to dedicate for the analysis of this material. Thank you very much to the interpreters for giving me these 5 minutes. We will now adjourn the hearing for, let's say, for 20 minutes, and then we will resume with... Mr. Prosecutor, do you need more time, or 20 minutes is okay?
That should suffice, Your Honor.
In 20 minutes, and then we'll move to defense investigations. Given that we will only have one full session of an hour and a half, I invite the parties to be brief in their presentation. Otherwise, we will not be able to deal with the measures to streamline the case today. So I hope the parties will be able to be brief so that we can finalize the agenda today. The hearing is adjourned.
All rise. All rise. Please be seated.
So, Mr. Prosecutor, before we proceed with the defense investigations, you have the floor for the 1023 material.
Thank you, Your Honor. I did predict that it would be difficult to reliably estimate. That turned out to be true, but we do have a time frame for you. I can even share a couple of the considerations that came up in that discussion. One is the scale of the Rule 1023 notice. It's an order of magnitude bigger than all of the other cases, as Your Honor is aware. It's not necessarily the case that the size of a case correlates perfectly with the size of the Rule 1023 notice. You might have a very big case with lots of Rule 1021B items, for instance, but this is certainly the case here. We also have a huge scale of items that are selected. And it's true that some defense teams are being more selective than others, but collectively, as we said, and as Your Honor recalled, 97% of the items in this order of magnitude bigger notice have been selected. But bearing all of this in mind, with the caveat that the requests freeze now, so looking at the requests that have come in as of this moment and not accommodating future requests, we're currently projecting that we can finish the Rule 1023 notice request currently made by the end of September of this year. The last point that we wanted to make in this regard is that we maintain our position. We appreciate what Your Honor said, that you want this matter resolved before transferring the case to the trial panel, but it's a different matter as to when exactly the pretrial brief is filed. We maintain our position. It's not necessarily required to have this Rule 1023 notice completed as a prerequisite to filing the pretrial brief. At the International Criminal Court, as a comparison, full disclosure is generally given 3 months before trial and generally after the pretrial phase has finished entirely, including pre-confirmation briefs. So it's admittedly a different statutory scheme and a different system. We just want to say that Your Honor's timetable for pretrial briefs doesn't necessarily need to be tied to the timeline that we're indicating. But Your Honor's asked us for an estimate, and this is our estimate.
Thank you, Mr. Prosecutor. Let us now move to the defense investigations and next steps. Today, I will give the floor to the parties separately on each item related to defense investigations. First, on the general status of the defense investigations. Second, on any potential request for unique investigative opportunity. Third, on any notice of an alibi or grounds for excluding responsibility. Fourth, on points of agreement on law and/or facts. Fifth, on objections to the admissibility of evidentiary material disclosed. And finally, on the defense pre-trial brief. I invite the defense teams to be very concise for each item because we are going to run out of time soon. Let us start with the general status of the defense investigations. In its written submissions, the defense indicates that it is continuing its investigations, including identifying potential witnesses, conducting investigative missions, and reviewing evidentiary materials disclosed by the SPO. However, the Thaci defense recalls that these investigations remain hampered by a number of factors outside of the control of the defense, notably the extensive redactions applied by the SPO and the delayed and partial disclosure by the SPO. The Krasniqi defense also considers that certain investigations cannot be completed until after the SPO has completed its disclosure obligations. So I would like the defense teams to give a brief overview on the status of its investigations. Mr. Kihu, please.
Yes, Your Honor. Would you like me to address all those issues at once, or would you take them one at a time?
One at a time.
First issue, Your Honor, I think Your Honor clearly outlined our position. We are continuing with our investigation, but mind you, the redactions, not only in the indictment, the pretrial brief, and more importantly, these witness statements are not only extensive, they're extremely, extremely voluminous. Makes it very difficult on matters to even in an instance when we were going through a transcript of one of the interviews, one of the items is referenced, a particular document is referenced in it. When we go to get the ERN number for that document, the entire document is blank. So we don't even know what the witness is talking about. We have a witness talking about a document, but we can't even read it. Makes it almost, well, virtually impossible to find out exactly what they're talking about without that document. Your Honor raised, and I'm not here to go back into the protective measures, but of course, 100 witnesses have protective measures at this point, remain anonymous. 65 are going to remain anonymous until 30 days before trial. That is an enormous undertaking for the defense teams to investigate and look into 69 witnesses 30 days before trial. And then there's going to be the concomitant delays, that several witnesses, I believe it's 24, are going to will be revealed to us 30 days before their testimony. And I believe there are 4 others that are going to be triggered by their 30-day period, which makes it 28. And then there are 2 witnesses that were never ever going to get their identity. And I submit to Your Honor, I've never been in a trial or court proceeding in my life where that has been the case. Nevertheless, Your Honor understands what the difficulty is investigating this matter. That's not to say we're not investigating this matter. We are investigating this matter, but we are truly, truly hampered by the extensive redactions that have been imposed on the witnesses and the witness statements. That being said, my client and the other accused want to move this thing to trial, if in fact, if sooner as opposed to later. But I have to tell Your Honor about the difficulties that have come as a result of this. And on a separate issue that we just received some clarification on yesterday, I had sent a letter some time ago to the OSCE with regard to certain information. And I recently received a letter back saying that the registry was coming up with some type of protocol for this to get these documents. I don't think that the SPO had to go through such an endeavor to try to look at these documents, but be that as it may. And then I just got a note yesterday through Ms. Menegon from the registry saying that requests had to be made through the court to look at OSCE documents. And I'm a bit at lost on the entire procedure because none of this that I can see is in the rules, given the fact that I just sent a letter to the OSCE and the UN asking for that documentation. But if there is some guidance that Your Honor can give us to expedite this, we need these OSCE documents as soon as possible, and we want to do what we need to do to get compliance with any edict this court might rule on this score, and to move this matter along as quickly as possible.
Thank you, Mr. Q. Mr. Emerson, please.
Defense investigation for Mr. Vasili is proceeding well and will continue over the summer. We expect to be ready to start a trial this year.
Thank you, Mr. Vasili. Mr. Young, please.
Your Honour, defence investigations are ongoing in terms of reviewing the disclosed material, the pre-trial brief and meeting persons of interest. As Mr. Keogh has said, we are hampered severely by and we don't seek reconsideration of your decisions in relation to protective measures, but the extensive anonymity orders and resulting redactions to the indictment pre-trial brief do seriously impact upon our ability to investigate.
Thank you, Mr. Young. Ms. Salagendra, please.
Your Honor, defense investigations are ongoing, and I echo the difficulties that have been mentioned by Mr. Keogh. We face a similar situation.
Thank you, Ms. Salagendra. Mr. Helling, do you want to?
Just briefly, the only thing we wanted to say is, of the 4 defense teams, only one of them gave any sort of meaningful update on the progress of its investigations, and even the Thaci defense only talked about one thing. It's a shame that we had to talk about Dick Marty and Serbia for almost an hour in order to have such a concise discussion on this topic. And we would ask Your Honor consider at a future status conference to change the agenda order, because this keeps happening, and the defense need to give a more meaningful update on the progress of their investigations at a future status conference.
Your Honor,
may I be heard in my comment?
Very briefly, Mr.
Very
Q.
briefly. with the status of the investigation and these comments by defense counsel about what the defense is doing and not doing have no bearing on the failure of the SPO to meet their obligations and shouldn't be taken as such. This investigation is moving along as quickly as it possibly can. All of these teams are working hard with all of the information that the SPO has decided to redact and exclude, so we couldn't move this case along more quickly. And that's the reality of these investigations.
Thank you, Mr. Kihu.
Yeah, may I just add one?
Very briefly, Mr. Emerson.
It would be less than a breath, I promise you. If what is being called for by the prosecution is some sort of a detailed analysis of what the defense is doing by way of investigation, then I'm afraid the gentleman opposite is going to be sadly disappointed. There is no question of us disclosing the content of our investigations, but merely the progress and timelines.
Thank you, Mr. Emerson. Let us now move to requests for unique investigative opportunity. In their submissions, two defense teams provide information on their intention to make requests concerning unique investigative opportunities, pursuant to Rule 99(1) of the rules. The Thaci defense indicates it will make such requests for a number of potential witnesses. The Thaci defense anticipates that any such request will be submitted within the coming months in order that the depositions be taken before the end of the year. The Vesely defense has also identified individuals from the SPO's list for whom a request for unique investigative opportunity may be made. So I invite the defense to give a timeline for these requests. Mr. Kihu.
I will tell you, Judge, that we have, at this point, 9 people that we want to depose before trial, and we do that because of age considerations and, most importantly, deteriorating health. These events took place back in 1998, 1999, and some even before then. And some of the individuals who were on the ground there at the time, certainly some of the internationals, are not quite advanced. Now, I'm not wishing any ill health on them, but the reality is that if, in fact, we're dealing with 1,500 hours of a prosecution case, in their case alone, we're talking about looking at a defense case years down the line. And some of these witnesses have opined that for a variety of reasons that their evidence should be secured now for health and just general well-being of any of these witnesses. And again, some of them are in advanced age and into their late 80s. So we will be presenting at least 9, and I suspect it may even be more than that, Judge, to put those matters before the court, before the trial chamber. Much of that information concerning what we're going to testify to is tied to the UN documents, the OSCE documents, and the documents for which we've been trying to get, and we have been unable to do so. So one is going to follow the other. I intend to move through this as quickly as I possibly can, but these witnesses have asked for the hardcore documents, which is why I was back at the UN and the OSCE asking for these documents. And that's the process and the procedure that we are going through right now. But I promise you, Your Honor, that it will be done as promptly as we get these documents, the witness can review them, we can get those health concerns, et cetera, and the reason why we should move ahead with this deposition before the court as soon as possible. As an aside, Judge, any guidance that Your Honor can give us as to how we should move this along, we would take it, we would accept it gladly, because we want to do this as quickly as possible so this matter can get to trial.
Thank you, Mr. Kihu. This will be done in communication with the registry, not in this status conference. Mr. Emerson, please.
I have nothing to add at this stage.
Thank you, Mr. Emerson. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Ms. Lagendra, please.
Your Honor, we are liaising with the other defense teams, and should additional requests become necessary, we will make them in due course.
Thank you, Mr. Lagendra. Let us now move to the notice of an alibi or grounds for excluding responsibility. In their written submissions, the defense reserved their right to give notice of an alibi or grounds for excluding responsibility. The Thaci defense is unable to provide further information now due to the scale of redactions in the indictment and the evidentiary material. The Vesely defense has proposed that the SPO allow defense counsel on a strictly confidential basis to see redacted material relating to any direct allegation against the defense in order to assist them on this matter. The SPO indicated that this would require a variation of protective measures. I invite the defense to indicate when they will be able to give notice of an alibi or grounds for excluding responsibility. Mr. Kihu.
Yes, Your Honor, our position with regard to alibi defense on any of these items that are in the indictment remains the same. We can simply not give you an alibi concerning most of the matters that are here because of the massive redactions that the SPO has put before Your Honor. Now, I will tell you, frankly, Judge, that there will be an alibi defense on any number of items once we get clarity on these dates and places, because my client was certainly, during most of '99, visiting capitals throughout the world and dealing with internationals to try to bring peace to Kosovo in a diplomatic fashion. This is while a war is raging. Now, where he was at all of those times, if I'm going to give an alibi defense, it's incumbent upon us to say on a particular date he's in Oslo, or he's in London, or he's in Geneva, or Brussels. And I can't do that with what we have before us right now. But I will say that again, Your Honor, we will, once we get clarity on these dates, times, and places, be able to present that to the court.
Thank you, Mr. Kihu. Mr. Emerson, please.
Yes, well, on dates, times, and places, those are the issues that need to be clarified before we can be put on notice of any requirements for serve an alibi, insofar as presence in a particular place at a particular time is what constitutes an alibi.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honor, at this stage, we're unable to provide any information at this juncture due to the size of the unknown materials, and so I really don't make any submissions today.
Thank you, Mr. Young. Ms. Alagendra, please.
Your Honor, we reserve our right to give notice of an alibi. We are unable to do that at this stage.
Thank you, Ms. Alagendra. Let us now move to points of agreements on law and or facts. In its written submissions, the Thaci defense indicates that it has accepted 9 of the facts proposed by the SPO. In order to expedite the process of reaching agreement on the SPO's proposed facts, the Thaci defense invites the SPO to provide a lesser redacted version of the indictment and a lesser redacted evidentiary materials as soon as possible. The Vesely defense indicates that it has taken under review a number of proposed agreed facts that do not appear to depend on the completion of Rule 103 disclosure and should be in a position to revert to the SPO on this issue within the coming days. And the Krasniqi defense is reviewing the SPO's proposed agreed facts but cannot respond more substantively until disclosure is completed. I invite the parties to give a timeline for their discussions on this matter. Mr. Kiu.
Your Honor, just to echo what you said in the last conference, that when the defense hasn't received all disclosure, it's difficult for the defense to agree on facts. I think we're pretty much at the same place of talking about disclosure and agreeing on facts so you can contextualize these particular facts, which we will do to the extent that it can shorten this trial and get it to trial. But without disclosures, it's impossible to contextualize. We still have the 102.3 material to get. We have 103 material to get, and of course, to the extent that the identities of 100 witnesses make the whole acceptance of facts problematic, that remains the same. That being said, we will commit ourselves to looking at any facts that any other defense team, such as counsel just proposed, and see if we can go along with those at the appropriate time.
But you indicated in your written submissions that you already accepted 9 facts.
I accepted 9, Judge. I think
despite not having access to the whole disclosure, it doesn't prevent you from doing so.
I did, Judge, and I think that's a wonderful gesture on our part that we did that. We'll get past the salamander issue, and we now have 9 facts that we've agreed to. So I thought that was quite magnanimous. But nevertheless, Judge, look, it is in our interest to do so to the extent that we could do it, Judge, and certainly we will look at any other factual agreements that other counsel have to advance, and we will make a determination whether or not we can accept them.
Thank you, Mr. Kihu. Mr. Emerson, please.
We will have our response to the prosecution on the proposed agreed facts by the end of this month, so by the middle of next week.
Thank you, Mr. Emerson. Mr. Young?
Your Honour, we're still actively reviewing the facts to determine whether or not we can agree to them. Clearly, we'll notify the SPO if and when that can happen. In terms of law, the absence of any submissions on the law in the prosecution pre-trial brief render it almost impossible to have any useful discussions on this point, but we will actively seek to make agreement where we can.
Thank you, Mr. Young. Mr. Lagendra, please. Mr. Bayezou.
Yes. On the agreed facts, as we submitted in our written, as we made the submission in our written filing, we cannot comment any further at this stage due to incomplete disclosure. We are actively reviewing, and we will, in due course, update the court. Thank you.
Thank you, Mr. Bayezou. Mr. Prosecutor, do you want to add anything on this topic? And are you inclined to make proposals on agreed points of law as well to answer the question of Mr. Young?
I mean, in this regard, Your Honor, we actually are on the record with a lot of the law. The entire preliminary motions litigation was a huge referendum, including our full position on many of the most important points of law in this case. So we actually don't accept the submission that we aren't saying anything about the law. We have to be on record with facts, law, evidence to a much larger extent than the defense teams at this point. I think our position is pretty clear on a great many things, and it really is at this point. We sent dozens and dozens of agreed facts in March of last year for the defense to come to us on what they actually can agree to with the state of disclosure and redactions and et cetera. It's really reached a point where us making further proposals doesn't look like it's going to be fruitful.
May I quickly respond to that, Judge? And the reason why in many cases is not fruitful is because what they are putting argumentative statements within their facts. I mean, they'll give this recitation from their indictment where there are redactions everywhere, and they'll pluck out an individual sentence and put that in as an agreed fact. Well, without the contextualizing what they're talking about, we cannot in good conscience agree to those facts. And if you look at what they propose and compare it to what they've disclosed, I think Your Honor will see exactly what I'm talking about. So this whole idea that, though, once again, we've met our obligations and everything is crystal clear and we've done everything to move this along is just simply not accurate.
Thank you, Mr. Kihu. I don't see any requests for the floor, so let us now move to the defense pretrial brief. In their written submissions, the defense teams indicated that they all intended to file a pretrial brief. The Thaci defense and the Vesely defense considers that they should be in a position to file their pretrial brief by 16 September 2022. However, the Thaci defense indicates that this is contingent on the SPO fulfilling all its disclosure obligation by 22 July 2022 and giving notice of the witnesses that it intends to call during the first 6 months of trial and the order in which it intends to call them by 22 July 2022. The Vesely defense considered that disclosure should be finalized on a tighter calendar and that the SPO should complete its Rule 103 disclosure of new materials by the court-imposed deadline of 20 May 2022, and all other Rule 103 disclosure by 22 June 2022, and provide to the defense all material requested pursuant to Rule 1023 by 22 July 22, with the understanding that the defense completes its Rule 1023 requests by 22 June 2022. The Krasniqi defense also considers that the date for the pretrial brief is linked to the remainder of the procedural timetable, in particular the date when the SPO completes its disclosure. So I invite the parties to develop their arguments on this matter. And I also inform the parties that at the end of this hearing, I intend to set a tentative date for the defense to file its pretrial brief. Mr. Kihu, please.
Yes, Your Honor, we're committed to filing our pretrial brief on the 16th of September. Obviously, we need the disclosures that the SPO has committed itself, well, Your Honor has ordered them, they haven't committed themselves. Your Honor has ordered them to comply with in order to, file this pretrial brief. But, Your Honor, the consideration of not only fulfilling its 103, 102 obligations is also, if we're going to move this case along and we want to file a pretrial brief and we want to get this to trial as soon as possible, and it's everybody's interest to expedite this matter, give us the witnesses for the first 6 months in the order that they're going to proceed on. That's the easiest way to move this along without any unnecessary delays.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honor, I said I'd come back to this question of the list of witnesses. Essentially, the question was posed directly in Your Honor's agenda, whether or not the defence could meet a 16th of September deadline. We've taken that as an invitation to look at the procedural consequences, which would first of all be referral to the trial chamber once that brief is filed, and then a sensible date for trial. And so far as we are concerned, we certainly can meet the 16th of September deadline for the pre-trial brief, with all of the caveats that would go with it. For example, if material was disclosed subsequent to the pre-trial brief that was relevant, then we would be in a position to either amend or at least not be criticised for its absence at the time the pre-trial brief was submitted. But the aim here is to have a pre-trial brief on the 16th of September to enable the trial to start in December. And since all attempts to impose discipline over the prosecution's timetabling, and frankly over the undisciplined and lazy scope of the case, in other words, a strategy, as Your Honour said earlier, of determining the scope of the case in a manner which has lost, if it ever had, any focus at all. Since those attempts to manage the prosecution's conduct up until now have failed, the only effective way to get this moving is to attack it at the opposite end. In other words, we will ask Your Honour to set a provisional trial date in December for the opening of the prosecution case, so that we can work backwards from that. 16th of September fits conveniently within a 3-month gap to enable that to occur. Now, the reason why, first of all, disclosure must be complete, subject to any minor matters that are identified clearly in advance, is that gives us approximately 6 weeks or so following disclosure to finalise our pre-trial briefs. Now, we can have that, we can work with some difficulties around the edges, but it's time to move the case forward and to put the prosecution under some real discipline, with guillotines and time limits and sanctions for failing to meet them. So yes, the 16th of September would work well for a pre-trial brief for the Thaci team, but we are also insisting on a trial that starts within a period of approximately 2 years since they've been detained. And so since we are in continual detention, this trial must start this year.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, very briefly. Your Honour, the defence is considering whether or not to file a pre-trial brief. As Your Honour understands, there's an invitation and it's not obligatory. If the defence does file a pre-trial brief, we would propose that the deadline of 16th September may be appropriate, but it's contingent in our submission on the conditions that were so clearly set out by the Thaci defence in their written filing. Obviously, much will depend upon what Your Honour orders in terms of timelines for the disclosure of the Rule 1023 materials, because the defence have put forward one figure, and now you've been told by the prosecution that they can give an undertaking to file it by the end of September. So we're in Your Honour's hands. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, very briefly on that, it's always been our position that the pre-trial brief needs to be tied to the end of disclosure. And the 16th of September, looking at the way Your Honour structured the order, was allowing a period of approximately 2 months between the end of disclosure and the defence pre-trial brief. That's still our position. We could do it within that 2-month window, But if the prosecution disclosure is slipping back, it has an effect on the defence pre-trial brief as well. So my position is 2 months following disclosure.
Thank you, Mr. Ellis. Mr. Prosecutor, and if you can respond to the timeline and also to the proposals of some defense team to have access to the witness order that you intend to present at trial. Thank you.
We can address the witness order issue first, Your Honor. We've actually said this at a previous status conference. The order of witnesses is very dependent on when exactly the trial commences, the sitting schedule of the trial panel, and the availability of our witnesses. So in our submission, the witness order is something that is better determined at the trial phase with the trial panel. So any witness order that we provide now, I mean, even understanding that it might be subject to change, it would be subject to change in so many various ways at this point that we don't think that that would be a meaningful order at this point. As we said before, that witness order should also not be conditioned to the pretrial brief. Turning to the pretrial brief, and this goes again to the submission I made earlier, that it would have been better to have had a longer discussion on this point because many of the submissions you heard just now are simply unclear. The Krasniqi defense is the only defense team that actually acknowledged how the 16 September deadline of Your Honor interplays with the end of September deadline I said just now. So when the Thaci and Veseli defense teams say they can file on the 16th September if their conditions are met, I don't know what that means because the conditions that they want, we've already said what is possible within those conditions. So they actually haven't committed to any particular timeline to file the pretrial brief. The second point that we wanted to stress to Your Honors is that for many of these defense agenda items, they talked a lot about the state of the redactions, which, as Your Honor knows, goes to delayed disclosure witnesses. Many of them are delayed disclosure witnesses 30 days before trial. They're not going to get those redactions lifted at the point that any pretrial brief would need to be filed. And we're concerned by some of these defense submissions when they say they need full disclosure, they're essentially creating a situation that can't ever exist, whereby they're waiting for redactions to be lifted to file a pretrial brief that can't actually be filed before Your Honor.
May I respond to that?
Thank you, Mr. Prosecutor. Mr. Kihu first.
Your Honor, that's
and before I give you the floor, if you could also indicate what would be a possible date for your pretrial brief if the SPO would finalize its 1023 obligations, disclosure obligations, at the end of September.
Well, I would say generally, and in accordance with what the counsel said previously, normally you take 2 months after they complete their disclosures. But I trust, based on the track record that we've had to date, I hope I hope that at the end of September is some realistic date, and is not just a date that counsel is throwing out to appease Your Honor at this point. So what we're looking for is we want full disclosure. Put aside the nonsense that you just heard. We want full disclosure so we can file the appropriate pretrial brief and move this case to trial. That's what we're looking to do. Not some moving the chess pieces around the board for some type of obtuse argument. No, just the order, following Your Honor's, what Your Honor is saying, what they're supposed to do, when they're supposed to do it, and we can file a pretrial brief no later than 2 months after that. And by the way, Judge, I mean, with regard to the witness order is very meaningful. Of course, there are going to be changes in the witness. But to expedite this matter and to move it along, there is going to be a certain pattern that the prosecution wants to follow. How do I know that? I did that for almost 25 years as a prosecutor. You know the direction you're going to go, and yes, there's going to be exceptions to it. But to say that there are exceptions and deletions, and as a result, the entire endeavor is not meaningful, is just not accurate. The prosecution at this point, as they sit here, knows the direction they're going to go in their prosecution and who, in all likelihood, they're going to put on in the first 6 months. That's all we're asking for. We're asking for it because that will enable us to move this case along in something less than the 3 years that counsel has put before your court with, 1,500, 1,600 hours of witness testimony.
Thank you, Mr. Kihu. Mr. Emerson, please.
Two brief points in response to counsel for the SPO. First of all, in his shrill and rather excitable submissions, he was trying to suggest that a date he'd pulled out of the hat just after consulting with colleagues over the short adjournment was such as to render our commitment to this court meaningless because we couldn't complete it or deliver on it if the SPO itself claims that it can't meet its disclosure obligations by the date that's specified. In other words, the cumulative breach of orders by the SPO is relied upon to cast doubt upon our commitment to file a pre-trial brief. I mean, not only is that completely illogical and it explains very clearly the need to start setting deadlines at the opposite end of this process, but it was also expressed in a rather intemperate way. The position is very clear. We will file our pre-trial brief on the 16th of September, even if the prosecution has yet by then to fulfill its obligations in relation to the final disclosure material, all of which is relating to requests that have been given to date. Right, so you're basically being faced with a submission that because we don't keep to our obligations, you can't trust the defence. Well, we will meet our obligation to have a pre-trial brief served on the 16th of September. But the implication for that, and I'm glad to hear the SPO would find this useful, is that we need to know the start date of the trial. Because at that point, once we've filed our pre-trial brief, things ought to move very, very speedily to trial. And since the prosecution say, well, we can't give you a witness order until we've got a date for trial, we're going to invite you to set the 16th of December as the start date for the trial. That gives us 30 days before then and the holiday period to look at the material that's been de-redacted the 30-day period before, which will be intense work. And it also gives us the opportunity in those circumstances to get from the SPO the order of the witnesses they intend to call. Otherwise, I mean, if you think about the way this case is being prosecuted, just in terms of scope, the sheer number of witnesses, we're going to come on to streamlining in a second, but given the, it's rather like a whale which digests krill, you know, just opening its mouth and allowing the evidence to swim in with no process of proper filtration. Because the volume of material, of highly tangential material the prosecution wants to include within its case, makes it impossible for us to anticipate the work we need to do to be ready for trial without an indication of which witnesses are going to be called. Since that's contingent on knowing when the trial starts, please, we would ask you on to say, yes, 16th of September, come what may, but equally, trials start on the 16th of December.
Thank you, Mr. Emerson. Mr. Young, Mr. Lagendra, do you want to add anything?
No, Your Honor, nothing to add.
Nothing to add. Good. I will issue an oral order at the end of this hearing on this topic. Let us now move to the last topic on our agenda today, which is related to efficiency and expeditiousness of the proceedings. In the scheduling order, I ask the parties whether they can provide an update on their inter partes discussions and present their proposals concerning the streamlining of trial proceedings. In their written submissions, the parties appear to be in agreement that they all should be entitled to call evidence as they see fit within an overall hours limit. The SPO indicated that it will significantly reduce its examination hours compared to its previous estimates. I invite the SPO to give figures, if possible, on the number of hours it now foresees. The Thaci defense submits that the admission of testimonies in writing instead of viva voce may be a way to accelerate trial proceedings, particularly for witnesses whose testimonies are duplicates or who do not refer to any accused. However, the Thaci defense considers that its scope shall necessarily be limited and the defense will object to the admission of testimonies in writing which relate to the acts and conducts of the accused. I invite the parties if they would all agree with this approach. The Vesely defense, supported by the Krasniqi defense, proposes to set a time frame for the parties to present their respective cases and proposes that the SPO should have 1 year to present its case with a possible extension of 3 months for unforeseen delays. According to the Vesely defense, this would result in a 2 to 3 year trial. I invite the parties to indicate if they agree with this proposed general time frame. According to the written submissions filed before the status conference, inter partes discussions have not been successful on several other topics. For example, the SPO indicates that no defense team made a proposal to accept the admissibility of any evidence on the SPO's witness list. And likewise, the SPO refuses some of the proposals of the defense, such as permitting defense counsel to review redacted material, which would involve a request to reconsider prior protective measures, providing the defense with a list of witnesses that it intends to call in the first 6 months of the trial, and we just discussed about that, cutting all allegations that do not involve the personal conduct of the accused or other named JCE members, or dropping any witnesses or crime site at this stage, considering that victims have waited 20 years to testify and need an opportunity to do so. So I indicate that I've requested written submissions today, so this is not going to be the only forum for discussing about these issues. So I invite the parties to present their views briefly on this topic, knowing that it will also be discussed in the next status conference. But I figured it would be useful to have preliminary views of the parties on this. Mr. Prosecutor.
Thank you, Your Honor. And just for the record, our intervention will actually only be oral today so that I can give you the full update of what we have on this topic. And Your Honor summarized the submissions accurately. As set out in the written submissions, inter-parties discussions have provided a consensus that the party should be free to present its respective case, subject to an established time frame. The overall length of the case or the overall length of the trial depends on the sitting schedule and how many breaks there are in the sitting schedule. So we would say that it's again not going to be very efficient to try and divine such information. You really need the trial panel with the information that the trial panel has on the sitting schedule to determine that with precision. As set out in the written submissions, the SPO is reducing its hours estimates internally. And again, the trial panel is the best place to set that overall hours limit. The internal review is taking many factors into consideration. Your Honor mentioned a particularly important one, that there are victims who have been waiting over 20 years to testify and tell their stories in this case. We would invite Your Honor to set a deadline shortly before the case is transferred to the trial panel in order for us to give a revised number on a streamlined overall hours estimate. Your Honor asked for figures. As an interim update, this isn't the end of the exercise, but the overall hours estimate is down 500 hours and it's continuing to drop. Again, we're going to be continuing to do this up until the moment that the deadline that we just contemplated would be set. As we said in our filing, the information that actually affects the scope of the defense investigations, like the dropping of any witness or crime site, we wouldn't wait until the deadline that we have in mind. We would communicate that promptly to inform future defense investigative decisions.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, Your Honor, certainly we accept the reduction in the time frame going from 1,863 hours to, I believe, something in the area of 1,363 hours. We previously asked the SPO if they were going to reduce the number of witnesses and the hours per witness. They did not respond to that. That, I believe, is something that the court can impose, asking the number of witnesses and the hours for each of those particular witnesses. We join in the Vesely submission with regard to a time frame, a year to put on their case, would be more than sufficient time for this, and give some structure to this so that we're not here to the next millennium. And just putting a year on for the SPO to put the case is appropriate, and the defense can divide time accordingly, depend on how much time that they get. I know, Your Honor, I'm not attempting to relitigate the protective measures issue. I understand that is a matter that's been decided. But that being said, some of the time frames with regard to when the information is disclosed to us makes it difficult for timing. We want to move this case to trial as quickly as possible. And we have 24 witnesses that we're going to get information 30 days before trial. 4 witnesses that will be revealed contingent on something of the 24, and then 69 witnesses 30 days before trial. It would expedite matters significantly as we move into trial if those timeframes were rethought by the court at some point to begin the disclosure on that information well before these 30-day trigger points. And if we consider that and we move it up, I do believe that will expedite matters once we get in the courtroom and we'll be ready to go. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honor, I have very little to add on the first part of this analysis, which is, should this be an overall hours limit imposed on the SPO, or should it be an overall time limit on the presentation of the SPO's case? Your Honor has the thrust of our argument, which is if the SPO is faced, as the defense would be faced, with an absolute outer limit as to the time that they could present their case, subject to showing cause for an extension, that has the automatic effect of focusing minds on what is really necessary for the trial panel to decide this case. And I entirely understand that my learned friend has to balance in the equation the rights of victims to have an opportunity to see justice being done. You also have to bear in mind that the accused are in custody, and that is a countervailing consideration. Because the reasonable time guarantee in Article 6 of the European Convention presupposes a faster timetable for those in custody than those on bail. And more to the point, it presumes that the tribunal has adequate time and facilities to run the case efficiently once it's begun. So at the end of the day, we would ask Your Honour to remember that if you accept our submission, or if the trial chamber endorses our submission, that there should be an overall limit of months that the prosecution has to put its case. The consequence will still be that if these men are acquitted at the end of the trial, and I certainly hope they will be, that they will have spent 5 years in custody. That's a pretty shocking state of affairs. And I mean, I'm not trying to relitigate the issue of provisional release because it's too late at this, since we're in the final rundown to trial. If there are no further delays, we're facing the situation that we are. But that's 5 years before a verdict. And anything that contemplates going beyond that is in our submission unconscionable and would involve this tribunal in breaching the basic principles of trial within a criminal matter within a reasonable time. So it's not our fault the prosecution has taken 2 years in discharging obligations when it said it could be ready for trial a year ago. It's not our fault that they've chosen to be indiscriminate in the number of witnesses that they've trying to pack in, that they're trying to fit, as the old expression in English goes, a quart into a pint pot. But to suggest that they are simply cutting the time for the existing witnesses, so the same number of witnesses to be called live, but just trying to deal with them at a double quick speed, I'm sure that the interpreters and the transcribers will have something to say about that type of compression. But be that as it may, it's not the exercise that the prosecution needs to go through. The exercise it really needs to go through is to look at the evidence that it's proposing to court, which seems to be reflective of its understanding that it has an obligation to call anybody in Kosovo who's made any kind of complaint, because the allegations on the indictment cover the whole of Kosovo and the entirety of the conflict, regardless of connections to any of the accused. And that being the case, the only way to get the prosecution to do its job properly is to impose a time limit on the presentation of their case. We can't be talking about a situation where these men have been in custody 6 or 7 years before the verdict. Otherwise, the impression will be rightly given that that is their punishment, guilty or innocent.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, very briefly, we wholeheartedly support the approach of the Veseli defence, which we think is eminently sensible, to fix a time period of a fixed time period of, say, 1 year, and hold the prosecution to that. In terms of the reducing the overall size and time for the case, frankly, Your Honour, as Your Honour knows, the burden remains on the prosecution. It's their case to suggest feasible, concrete and realistic proposals for reducing the time of the presentation of the case. So we're really in their hands, and hope that Your Honour will give them the direction that you can at this stage. As far as the reduction of hours is concerned, that's welcomed.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, as we indicated in our written submissions, we are still intending to file something in writing tonight on this issue, but we're strongly supportive of the proposals and the submissions made by the Vesely defence and by Mr. Emerson this afternoon. The sort of reduction that the prosecution is speaking about of 500 hours, of course it's welcome because it's something, but it's nowhere near enough. You're still looking at an extraordinarily lengthy prosecution case running into at least 3 years if there are no delays. So we would say that's nowhere near enough, and we stand by the proposal for a 1-year prosecution case.
Your Honour, if there's one point where we could reply, although if Mr. Laws wants the floor first, I'll cede it to him.
Mr. Howling, I will give you the floor, but please wait for me to give it to you. And before giving it to you, I will give it to Mr. Laws, the counsel for victims.
Well, thank you. We would like to make some submissions on this topic of streamlining, if we may.
Absolutely.
You know, it really comes down to this. What we want to say is that the decision as to who should testify in this case has to be driven by what the real issues in the case are. We're not in a position to affect the length of the case, and we can't propose ways to reduce the scope of the evidence. That's going to be something that falls to the parties, and for that reason we haven't filed. But the victims are directly affected by the length of the trial in 2 ways. First of all, some of them, as everybody knows, are also witnesses, and I hope that everyone would agree that none of those witnesses should be called unnecessarily. And secondly, all of the participating victims are understandably anxious that the trial should be concluded as soon as possible. So it's against that background that I'm just going to make these observations, if I may. The area in which there is the most room for saving court time is in relation to the witnesses dealing with the crime base. And everybody's familiar with that phrase, but for those listening perhaps elsewhere, what I mean by that is the evidence in relation to the commission of the crimes themselves. So in this case, that is the abductions, the detentions, the mistreatment, and the murders. And I do want to say that whatever may or may not be said about involvement of other states and reliability of evidence, at the end of this case, there's going to have been a substantial body of evidence which has been scrutinised and which stands the test of that scrutiny and shows that there were indeed abductions, detentions, mistreatment, and murders. The issue will be, is it properly linked to these accused? So against that background, we welcome the SPO's plan to make greater use of rules 153 to 155, and we welcome the Thaci defence's willingness, as expressed in their filing, to consider the use of those rules. But what we do want to say, for the record, is that there's an overlap between the streamlining issue and the last topic on the agenda today that we've just looked at, namely the pre-trial brief. If we look at Rule 95.5, we see what a defence pre-trial brief is supposed to contain, and everybody in the court again knows this. But to spell it out, the pretrial brief should identify the charges and matters that are in dispute. It should do so with reference to the paragraphs of the prosecution's pretrial brief, and it should give the reasons why those matters are in dispute. So it's a very specific requirement, which it's entirely it's voluntary to adopt the invitation of the court to file a pretrial brief, but if one does, that's what one's taking on by way of commitment. And the reason that that's important to emphasise, we submit at this point, is this. If the pretrial briefs follow the Rule 95.5 requirements, as I have no doubt that they will, then we should know, once they've been filed, much more precisely in relation to the crime base, what's in dispute and what is not. And that should make the task of applying Rules 153 to 155 much easier, and should make it possible, therefore, to streamline the case considerably once those pretrial briefs have been served. What we're really saying is that the decision about which witnesses should be called mustn't take place in a vacuum. So that the Thaci filing, for example, at paragraph 18, says that the defence stresses that it's for the SBO to streamline its own case and to determine which witnesses it will call to testify. And that's, with respect, obviously right up to a point, but it shouldn't be happening in a vacuum. What should be happening, we suggest, is that the decision that the prosecution have to take, and in due course perhaps the decision that the trial panel has to take, should be a decision which is taken in the light of the real issues in the case. So we'd respectfully suggest that whatever progress can be made now by way of reducing hours, but perhaps reaching agreement on some facts, is welcome, but that this is a topic that should be revisited at a later date, and the list of witnesses giving oral evidence should reflect the true issues in the case. That's to say, the matters that are really in dispute. That's all I wanted to say today on that topic. Thank you, Your Honour, for the floor.
Thank you, Mr. Laws. Before I give back the floor to the parties, starting with the prosecution, I invite the parties not to focus too much today on the question of calculating by hours or by year, because there is one variable that nobody knows for the moment, is how many days and how many hours a trial panel can sit. And this is something that needs to be examined. And once you have this variable, the number of hours and the total lengths will be relatively similar, because mathematically we will have the missing variable in the equation. Mr. Prosecutor, you have the floor.
Thank you, Your Honor, and sorry for jumping the gun earlier. But there's something that arose in the submissions that it's important that we address now, to borrow Mr. Emerson's language, to make a marker on it for future reference. And it goes mostly to what the Thaci defense was saying about the delayed disclosure orders. Your Honor has made these orders for 30 days before trial for these witnesses. The protective measures, decisions that you have taken have all been cumulative in the sense that you have been considering the fairness of the trial with the overall protective measures. And we noted with concern in the written submissions, and it was repeated again on this agenda item, that the Thaci defense seems to be saying that in the normal course of your delayed disclosure orders being lifted, they couldn't possibly start the trial in 30 days. And it sounds like they're trying to reserve a postponement request before this trial can start, and that is going to fundamentally undermine any of our streamlining efforts. And we wanted to put that concern on the record. Thank you.
Thank you, Mr. Prosecutor.
May I respond to that,
Kihu,
Judge?
please.
When Your Honor laid out your protective measures for all of these witnesses, I submit to Your Honor, you had no idea that the prosecution was going to come forward with 1,863 hours to put their case on. So that happened a long time ago, that Your Honor made a decision at that particular time with regard to those witnesses, not conceiving in 1,000 years that my good friends across the well were going to come in with that kind of time frame to put their case on. The suggestion that we were making is, if we ought to move this along and move it along quickly, not only pre-trial, but also during the trial, we respectfully request that Your Honor rethink some of those disclosure timeframes, because frankly, 69 witnesses, 30 days ahead of time is going, I don't know if it's going to delay things or not. It really depends on what those witnesses say. I've received so many blank sheets of blank, 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 blank from the prosecution, it's difficult to divine exactly what they're going to advance come trial time. But dealing with the abstract and abstracting that they have chosen, I merely submit to Your Honor that if we want to expedite, or a way to streamline this case, is to remove the 30-day time frame and expand it out, so when we do come to trial, things can move more quickly. I'm not reserving anything. I'm just giving a point of reference to Your Honor and to the trial chamber as a way we might move this more quickly. Now, if during the course of the trial, 30 days prior to a witness testifying, I could conceive of situations where it's impossible to get an array of witnesses there that you can just digest within that period of time. We may be able to. I don't know what these witnesses are saying. But if we're going to do things more quickly before and during the trial, so as Mr. Emerson said, these gentlemen aren't spending all of these years incarcerated before they receive a verdict, this is a way to do it.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honor, first of all, may we thank Mr. Laws for outlining so clearly the considerations that, from the point of view of the victims in this case, he urges upon the court. And I'd like, if I may, to respond in this way. He says, we would submit quite rightly, that the question of which witnesses to call is something which should be, in his words, driven by the real issues in the case. In other words, based on experience, he is submitting disputes about particular events which are not linked to the accused, may not require live evidence to be called. The real issues in the case, and there being obviously no practical dispute that certain crimes were committed in different parts of Kosovo by various individuals. The real issue in the case is, are the gentlemen in the dock party to a joint criminal enterprise that encompasses the commission of those crimes, or otherwise liable on one of the other modes of liability, such as command responsibility. But with that said, he rightly points out that it's in the interests not just of the accused who are in custody, but of the victims that he represents, that the trial should be quick. In other words, that it should not be unnecessarily prolonged. So far from the submission that was advanced to you on behalf of the SPO, that one of the issues you'll have to consider is that each of the witnesses or victim witnesses should have the right to come to court and have their day in court. That is not what Mr. Laws is submitting on their behalf at all. And no support for that proposition comes from the victims. Indeed, he specifically says in terms, he would hope it was unnecessary for victims to be called to testify and to relive their experiences. So there seems to be a rather different approach taken to the rights of victims by the person whose job it is to represent their interests, and the SPO, who may be seen to be using this as a pretext to avoid a proper and disciplined approach to the preparation and presentation of their case. That's the first thing I want to say. The second thing I want to say is that consistently with the casual flinging around of allegations against the defense, at paragraph 14 of their written submissions, the SPO accused the Vasily defense of bad faith by suggesting that the prosecution, one way the prosecution could cut its case would be to focus on the evidence alleged to connect the particular accused to the charges on the indictment. That was said to be bad faith because it ignores the modes of liability that are charged. Well, as you can see, it chimes exactly with the approach that's being urged upon you by the victims. And obviously, when allegations of bad faith, that's a serious allegation to make. They get thrown around loosely by the prosecution without censure. with absolutely no basis at all. Where the same submission is made by the defence, we are accused of acting in bad faith. Whereas, in fact, what we were submitting was identical to the submission that you've just heard, which is once it's clear, and I understand entirely Mr. Law's point that clarity will be enhanced by the pre-trial brief, but actually the prosecution knows their case and they know the evidence against the accused that they rely upon. And they're perfectly capable of focusing their prosecution case on the evidence they say implicates the accused. Why don't they? Because if you take the evidence that they rely upon to implicate the accused, it comes to nothing. The hope that they have is that by ventilating all these allegations in full, quite unnecessarily, that somehow the weight of the evidence brings their case home by the sheer volume and number of witnesses. Let me put it another way to you. The suggestion here is that if you do what Mr. Laws has just suggested, or if the trial chamber in due course orders the prosecution to confine the evidence it needs to call live to the evidence against the individual accused, connecting them to what they say is a joint criminal enterprise, prosecution resists that because they say, since it's a joint criminal enterprise allegation, we should be able to call everything that we think is relevant, including the crime base. Because as was just put to you a moment ago by counsel for the SPO, the victims must have their day in court. They've waited 20 years for this. Well, that is not the function of these proceedings. They must be conducted, of course, with the interests of the victim and the accused and the public interest, all balanced. That's the typical job of a trial chamber in any criminal case. To ensure that the triangulation of interests of alleged victim, accused, and the public interest are properly and fairly balanced. But what it doesn't do is in any way support the notion that the prosecution has liberty at large to take up 3 years of prosecution time in calling irrelevant evidence. So I mean, that's the first thing I wanted to say about it. The other thing I wanted to say about it is that it's important to understand the implications. So the prosecution are saying, we want plenty of time. We want what was likely to run into 3 years to present our case because it's a case of joint criminal enterprise. And the defense of the Vasili defense must be acting in bad faith when they say, as Mr. Laws just said, focus on the real issues. Because actually the real issues, say the prosecution, are the entirety of the evidence. Well, it's worth considering what that means because the position has been made, has been argued at various points in these proceedings, that in reality, this is a prosecution of the Kosovo Liberation Army as a whole. In reality, the prosecution's case is that the Kosovo Liberation Army itself was a joint criminal enterprise. In other words, in order to get home, they are seeking to prove that the liberation forces of an independent Kosovo counted as a joint criminal enterprise, of which these defendants, because they occupied nominal positions in a nominal command structure, must also be a party and indeed in a leadership position. They're on trial, as we've said many times before, because they were the leadership of the Kosovo Liberation Army, not because of any evidence against them individually. And the fact that the prosecution resists so strongly a streamlining of its case to the effect that it would focus on what Mr. Laws calls the real issues in the case, namely, how do you connect these accused to a crime committed when they weren't in the country in a completely different part of Kosovo to one that they'd ever visited, where there's no evidence of any order being made? The answer is, ultimately, the prosecution is trying to put the Kosovo Liberation Army on trial, and as the Serbian government would very much like to see, to delegitimize their claim to independence. Now, in reality, what has characterized the entire chaos with which the prosecution has conducted this case, and it's inevitable, we will all come back to the fact that they accused us of lying when we said it wasn't going to be possible to have the trial begin in May of last year. I was accused of deliberately, we were all accused of deliberately inflating the free trial period so as to improve our chances of applying for provisional release. And yet no apology, no retraction, no even shame for the way in which the prosecution is conducting its case. But right at the root of it, it's that they've got no focus whatsoever about in relation to these four accused. Why? Because these four accused are just symbolic. They're just members of the Kosovo Liberation Army in a nominally senior position. If they had to prove their case on the evidence against them, they wouldn't be able to do it, and they won't be able to do it. But they do need to be given some discipline, because it would be a gross injustice for these men to sit in the dock for another 3, 4, 5 years while the prosecution fiddles around and makes a complete mess of the whole case. And then to find that what we can say right from the outset, the evidence that the prosecution relies on against these individuals doesn't amount to a row of beans. And that's why they don't want to limit their case in that way.
Thank you, Mr. Emerson. I don't see any, I think it's Mr. Laws first, because it's the second round.
Very briefly, if I may, I certainly did not intend to support Mr. Emerson's proposition as set out in the inter partes discussions, which amounts to limiting the scope of the prosecution case. That was not my intention at all in my submissions, and if I gave that impression, then I hope a reading of the transcript will show that it's not what I said. It's not the scope of the case that needs to be limited, it's the way in which it is to be presented that needs to be carefully managed. And there's an important difference between those two situations. And I want to be clear about that. We're not saying that the crime-based evidence should in some way be excised from the case or ignored, not at all. Just that it should be dealt with in an efficient manner, and that is possible once the true issues have been identified.
Thank you, Mr. Laws. Mr. Prosecutor.
Thank you. Also briefly, and also a correction for the record, the SPO is not charging the KLA as a whole, and Mr. Emerson knows that, and we would ask him that he stop saying that. That's a dangerous submission to make, and it's not true, and it is eerily similar to statements made by the two gentlemen convicted on Wednesday. These people are charged as individuals, and the KLA is not being charged as an organization, and we wanted to make that clear. Thank you.
Your Honor, may I just say
Mr.
something?
Prosecutor. So if we go for round 3, it's Mr. Kihu. Very briefly, because it's late, and the interpreters, I think, are exhausted.
Your Honor, I understand that the prosecution doesn't want to say that they are prosecuting the KLA, but they are. And all you have to do is read paragraph 35, which lists virtually everybody in the KLA throughout the entire country who's part of this joint criminal enterprise. So to stand on this ceremony that we're not charging the Kosovo Liberation Army is just a specious argument. And I direct Your Honor to read at least paragraph 35, and it will make it very clear.
Thank you, Mr. Kihu. Mr. Young.
The prosecutor is, with great respect, being utterly disingenuous in making the claim that this isn't a prosecution against the KLA. It's nonsense. It's clear that they are. Everywhere one sees in the KSC website, there's a talk of the individual. It's all about individual responsibility, not about an organisation. That's a patently false, disingenuous suggestion. The only other point I make is, just in terms of courtroom ethics, I would ask Your Honour to direct counsel for the prosecution not to point like that. It's utterly unprofessional.
Thank you, Mr. Young. I don't see any request for the floor. So let us now move to the date of the next status conference. As indicated in my scheduling order, I intend to schedule the next status conference on Thursday, 30 June 2022 at 14:30 Hague time. As usual, I invite the parties to confirm their availability. Mr. Prosecutor?
We're available, Your Honor.
Thank you, Mr. Prosecutor. Mr. Kihu?
Yes, Your Honor, we're available.
Thank you, Mr. Kihu. Mr. Emerson?
Yes, Your Honor, but can I just take this opportunity to correct something that I said earlier. I think it's better corrected as soon as possible. At an earlier stage of the status conference, I misspoke. And I indicated that Nazim Blatzer was all dead. That is not correct. He's not dead. And the reason I'm mentioning it is because I've just been sent some media coverage that has picked up on that remark. So that needs to be corrected as quickly as possible. Thank you very much.
Thank you. And the status conference, 30 June, is it okay?
Yes, absolutely.
Thank you, Mr. Emerson. Mr. Young?
Fine.
Thank you, Mr. Young. Mr. Legendra?
We are available, Your Honor.
Thank you, Mr. Legendra. Mr. Laws?
Your Honour, we're available. Thank you.
Thank you very much. You will receive a scaling order in due course. At this point, I would like to ask the parties and participants whether they have any other issues they would like to raise. Mr. Prosecutor?
Nothing further, Your Honor.
Thank you, Mr. Prosecutor. Mr. Kihu? Thank you, Mr. Kihu. Mr. Emerson?
Sorry, nothing further.
Thank you, Mr. Emerson. Mr. Young?
No, thank you.
Thank you, Mr. Young. Mr. Legendra?
Nothing further, Your Honor.
Thank you, Mr. Legendra. Mr. Laws?
Nothing from us. Thank you, Your Honour.
Thank you very much. I will break for 10 minutes and I will go back with the oral orders related to the matters I indicated earlier. I'll see you in 10 minutes.
All rise. All rise. Please be seated.
As indicated before the break, I will issue 3 further oral orders. I will now issue my second oral order on Rule 103 material. In light of the parties' submissions, I order the SPO by 30 June 2022 to complete its review of material obtained after January 2022 and to file protective measure requests or disclose material falling under Rule 103. This concludes my second oral order. I will now issue my third oral order on the disclosure of Rule 102.3 material. In light of the parties' submissions, I order the SPO in relation to currently pending defense requests for the disclosure of Rule 102.3 material to first, finalize its processing of these requests. Second, request protective measures or submit materiality challenges. And third, disclose all material not subject to protective measures request or materiality challenges by 30 September 2022. This concludes my third oral order. And I will now issue my fourth oral order on the deadline for filing defense pretrial brief. In light of the parties' submissions, I order the various defense teams to file their respective pre-trial brief by Friday, 21 October 2022. This concludes my fourth oral order. This concludes today's hearing. I thank the parties and participants for their attendance. I wish to thank the interpreters, audiovisual technicians, security personnel, stenographer for their assistance as usual, and the hearing is adjourned.
All rise.